vis-a-vis the conflicting provisions which are there under the Companies Act, requires an amendment but not amended as on date. The clarity wherever required under the Companies Act, but still the clarity is coming either from the tribunal or appellate tribunal. So I would like to highlight upon various provisions of the Companies Act, vis-a-vis I will be taking care of the provisions of the IBC, which are either conflicting in nature, or else there is no clarity, or else there is a lack of clarity, or else there are the practical difficulties which are being faced by the RP or the advisor to the RP who are taking care of the post CIRP compliances upon approval of the resolution plan. I would like to keep the forum open for all the participants to come up with their grievance, suggestions, opinions, or any sort of conflicts which they feel are there in the provisions of the Companies Act in comparison to what is provided under the Insolvency and Bankruptcy Code. If it is not covered during the session, it can be intervened and it can be discussed. I would like to keep the things in a manner wherein we are going to take care of various provisions of the Companies Act in comparison with the provisions of the Companies Act which are referred to in the IBC. And we will be taking care of how the things are not in line with each other, where the inconsistencies are still prevailing, where there is a further clarity which is required from the IBBI in the Ministry of Corporate Affairs. There are multiple points which we are supposed to take care of. There are certain pointers which are there before me wherein I feel that here there is a requirement wherein the law is required to be clarified, or the creases are still there wherein the iron may either be strongly put on by the ministry itself by coming up with some clarity, or either the code should be amended in a manner so that the provisions of IBC are not required to be verified or looked upon, or else the amendment should be brought in the Companies Act. To begin with, I would like to say, when companies in CIRP, once the application is admitted under 7 or under 9 or under 10, we are completely aware of this fact that the power of the board of directors gets suspended and not their duties, not their roles. Of course, the role is being played by the IRP or RP or the liquidator immediately upon admission of the application. But my point is very much confined to the power gets suspended and not the duties. As far as the powers are concerned, the things are very clarified by the code itself, that the power of the board of directors are suspended. But there is no clarity in the entire code with regards to the power of the shareholders. I've seen many of the RPs during the course of CIRP making an application to the registrar of companies for seeking an extension in holding AGM. And this is what I witnessed. In fact, many of the RP has approached me for the said assignment. And my point was very singular, that where the AGM is required to be conducted. And I have got the cross from, or the other argument from the other side, or the argument from the other side is where the things are exempted under the Companies Act. I was very much convinced with his argument that there is no provisions of the Insolvency and Bankruptcy Code which gives a liberty or which gives a leniency to the insolvency professional who is acting as an IRP or RP for not taking care of the compliance of the Act. And most important, I would like to touch upon the provision of the code wherein it is provided that the IRP or the RP shall be held responsible for the compliances of various provisions of the Act, and not only the Companies Act, all the applicable Act. I'm just opening IBC for the sake of convenience of all. And in the meantime, if you have something to counter upon, something to coming up from your side, I'm going to entertain the same. But this is a very relevant point which I used to feel that I should discuss whenever there is an opportunity of having a discussion pertaining to conflicts in between these two acts. And that is what I said, that the power of the board of directors gets suspended. They are still duty bound. The power gets suspended and they are responsible to undertake the duties provided under the Act. We are going to take care of this particular topic, that is approval of the financial statement, the moment we will be out from this topic of the annual general meeting. And here the point is, I would like to say, when a company is a going concern, the certain powers are exclusively in the hands of the board of directors, and certain powers are reserved in the hands of the shareholders. The board of directors used to exercise such powers in the board meeting, and general meeting, the shareholder used to pass a resolution, an ordinary or special resolution, empower board to do many of the acts. For example, even if there is an alteration of the charter document like memorandum and article, the approval of shareholder is provided under the Act. Similarly, it is provided that the financial statements are approved by the board, and it is required to be adopted by the shareholder at the AGM before it is required to be filed with the registrar. So before filing it with the ROC, the financials get adopted by the shareholder at the AGM. So that is a power within the hands of the shareholder. But as far as the provisions of the code is concerned, I have not seen any of the provision talking about adoption of the financials by the COC. And I have not even seen any provision which says that no shareholders will be having any power during the course of CIRP. I have not even seen any provisions of the code which states that no annual general meeting or extraordinary general meetings are required to be conducted when a company is in CIRP. And during the course of moratorium, the shareholders' approvals are not required to be sought. So my point is, Section 28 of the code is very clear that for this item of discussion, or further for this approval, or for this purpose, the approval of the COC shall be required, and their voting share will be the 66% of the voting share. If they have the consent, or if the IRRP is getting the consent from this majority, the resolution will be passed. But the point is, the power of the board is getting suspended, but there is no provision which is expressly providing that the shareholders' power is getting suspended. I'm just sharing. Now, this is the point which I was sharing with you, 17.2e. I'm sharing for the sake of convenience of all. Is the screen visible? Is the screen visible to all of you? If you can please acknowledge, so that at least I can able to understand that whether the screen is visible to you or not. Yes, Mr. Jain. अंजलि, ये स्क्रीन दिख रहा है क्या? Okay, so this is section 17. This is section 17 of the Insolvency and Bankruptcy Code, and I'm talking about section 17, subsection 2, clause E. And when you see the provision of section 17, subsection 2, clause E, it states that it is the IRP vested with the management of the corporate debtor shall be responsible for complying with the requirement under any law for the time being in force on behalf of the corporate debtor. And as far as Companies Act is concerned, the provision of section 96 is applicable to all the companies, and there is no privilege, or there is no such kind of, you can say, a clarity within the act itself which states that no AGM is required to be conducted in case of a company which is in CIRP. Section 96, there is no exemption except to an OPC. So meaning thereby, provisions of section 96, which states that the company is required to call its AGM within 6 months from the closure of financial year, subject to condition that not more than 15 months shall elapse in between two AGM. Now, that provision is required to be complied by even a company which is in CIRP. But the point is, the purpose, the objective, the rationale, and the outcome, even if you are going to call a shareholders meeting. But considering the provision of section 17 subsection 2 clause E, which states that he shall be responsible for complying with the requirement under any law for the timing in force on behalf of CD, here I would like to say that mandates him to call the shareholders meeting, that is annual general meeting, even though a company is in CIRP, because unfortunately in the code itself, there is no clarity in this connection that where the power of the shareholder will be constrained or compressed. And unfortunately, even under the Companies Act 2013, there is no privilege or an exemption which is provided to the companies which are in CIRP with regards to the meeting of the shareholder or the annual general meeting. I hope you got the point. Now, this is one of the points which I felt it relevant because just before few days on event of this 30th of September, because now that is considered as a due date by which we used to call the annual general meeting, considering the provision of section 96, which mandates company to call its AGM within 6 months from the closure of its financial year. Now that 6 months gets expired on 30th September. And many of the insolvency professionals, those who have approached for the sake of taking up the matter for the sake of an assignment or for the sake of getting an opinion or for the sake of having a discussion in this connection, that whether it is required to be conducted or not, or whether the provisions of the AGM will be applicable to such companies or not. And my point was very clear that no shareholder would love to be there in that meeting. Second, no purpose is going to be solved. Third, no shareholders will be having any purpose of coming and joining the meeting, considering the provision of section 53 of the code, especially if this company is in that financial health which is or wherein the liquidation is inevitable. So considering all this aspect, I feel there has to be some clarity with regards to the power of the shareholder during CIRP. And I was on that topic that when a company is going concern, the power is with the board and certain powers are reserved for the shareholders. We know when company goes into CIRP, the power of the board of director gets suspended. The power of the board gets suspended, but there is no suspension of the power qua shareholders. And that is the only reason which again and again come to the mind of the insolvency professional when he is holding the chair of IRP or RP, that whether to comply and if to comply, whether the purpose is going to achieve if I'm going to call the shareholders meeting. But yes, if I'm not going to call the shareholders meeting, then in that circumstances, I will be in further great trouble, because the registrar of companies I've seen, even after the successful completion of the CIRP, they are serving the notice to the IRP and RP of the corporate debtor, which is now out of the CIRP. Because of the provision of section 17, subsection 2, clause E, which we have very recently studied, which states that, and that was inserted on 6th June 2018, which states that this person shall be responsible for complying with the requirement under any law for the timing in force on behalf of the corporate debtor. Yes, I would like to have the views of the participant in this connection. I will appreciate your interaction in this connection, because few of you must be acting as an IRP and facing the same trouble during the course of the insolvency resolution process of a corporate person. I'll be inviting your views in this connection, sir. What your viewpoint in this connection, that during the course of CIRP, when there is an express provision which states that the power of the board gets suspended, and this is provided, this is something which is provided, that from the appointment of the IRP, the management of the affairs of the corporate debtor shall vest in the IRP. That is something which is provided. The powers of the board of directors or the partner of the corporate debtor. Now, this is the word used for the LLP. The partners of the corporate debtor, as the case may be, shall stand suspended and exercised by an IRP. But this is all about the power of the IRP or RP. But now, what about the power of the shareholder, which is derived from the provisions of the Companies Act? And there is no express provision which states that such power of the shareholder shall also get suspended. And until there is an express provision, how this can be presumed? Unless the equivalent power is given to the COC, I don't have any arguments to put upon. But what about those items of the business wherein the COC is also not empowered? And in that circumstances, whether the shareholder's power shall be considered as if it is suspended, or such power shall be considered as if it is remaining in the hands of the shareholders. I will be appreciating, or I will enjoy the discussion with regards to. Yes, please. Yes, Mr. Jain. You are audible, please.
Hello, I am Rajendra Jain.
Yes, Jain साहब बताइए. You may put your concern in the chat box also, because your voice is audible, but it is missing in between.
To hold this AGM, these provisions.
Sir, please. I missed your initial point, but if you can please repeat, sir.
See, in case of this corporate debtors who are the privately limited companies, and where the shareholders are themselves the SBODs or the directors themselves the shareholders.
Absolutely, sir. So in that case, it is always presumed that the power is suspended.
So directors' powers are suspended, but as you said, that shareholders' powers are not suspended. In
Absolutely,
the capacity of the shareholder, still they have the powers as a shareholder.
Absolutely, yes. Because when you say when a company is going concern, and when we call a shareholders meeting, in spite of knowing the fact that these are the similar phase who are on the board, but when it comes to the matter of the shareholders approval, we go back to them and seek their approval in the capacity of the shareholder. So in that case, a distinguish between the power as a director and power as a shareholder is required to be made.
Most of the cases, this business has mostly closed. There are no businesses closed down for last many years, and they are only sitting on this.
Absolutely, sir. But I am not going much into the fact of the case. I'm going into the merits of the provisions of the law, that whether it is required to be complied, or it will be considered as if considering the same phase, let's avoid the provisions of the act and move further. Because there is no express provision in the Companies Act or under the IBC which states that you are not supposed to refer the matter back to the shareholder, especially the power which are only conferred upon them. And I have taken one of the example, and that is the adoption of the financial statement. Let us take the another one also. Let us take another one. This is the most relevant point, I feel. I've seen certain inconsistencies between few of the IRPs and RP are continuing with the same statutory auditor, and few of the IRPs and RPs are appointing a new auditor during the course of CIRP. Yes, I will appreciate your view, sir. And this is the concern with the auditors of the company. In the Companies Act, there is a provisions of section 139, which clearly states that if I'm appointing an auditor of the company, I need to appoint him at the AGM. The term of the auditor is going to be for the 5 years. Now, what in case if the term is going to expire at the AGM and the company is in CIRP? To continue with the same auditor during CIRP? To appoint a new auditor during the course of CIRP? That is one of the point of discussion which I would like to have with you. Yes, what is your say in this? Because I believe the provisions of the Companies Act, which is purely undisputed, that as far as the auditors of the companies are concerned, the auditors are not the officer and they are agent to the shareholders. So they are answerable and they are accountable to the shareholders of the company. It is the shareholders of the company who used to appoint them at every AGM, unless it is a case of the first statutory auditor, which is required to be appointed by the board. Now, my point is, if the auditor of the company was appointed by the AGM or by the shareholders at the AGM, whose tenure is going to be expiring at the 6th AGM of the company, let us consider that he was appointed at the first AGM. But in the course of that 6th AGM, or during the course of that 6th AGM, the company was in CIRP. As you said that when the company is in CIRP, generally the meeting of the shareholders are being avoided. Now, if the meetings are being avoided, in that circumstances, who else is going to take this call, or who else is going to take this decision with regards to the appointment of statutory auditor? And my point is, there is lack of clarity, or there is total ambiguity in this connection. I've seen many of the CIRP wherein the old auditor is continuing as a statutory auditor during the process of CIRP. And I've seen many of the insolvency applications or insolvency procedure wherein the RP is bringing his man as a statutory auditor of the company. Your views on this? To all the chartered accountants who are participating in this process, in this session, I would like to ask them that what is their take on this? Yes, sir. You're audible, please. If you can please come up with your point. Because I've seen here again, when you see the provisions of the Companies Act, it is all clear in terms of the appointment of the auditor, but there is no clarity in connection with who shall be acting as a statutory auditor during the course when the company is in CIRP. If we see section 28, which talks about certain powers for which I need to go to the COC for seeking their approval. Now, if I just refer to section 28 of the code, which is there and before the screen, raising of interim finance, okay. Creating any security interest over the asset of the corporate debtor, I will be approaching COC. If I need to change the capital structure of the corporate debtor by the way of issue of additional security, again, there is a complete clarity that I will not look after the provisions of the Companies Act, which mandates me to take shareholders' approval, because here the IBC will be having its overriding effect. Change in the ownership interest in the corporate debtor, okay, I will be doing it with the COC's approval. I will be giving instruction to the financial institutions who are maintaining the accounts of the corporate debtor for debit transaction from such account in excess of the amount as may be decided by COC. Okay, I will be approaching the COC for seeking their approval. Taking to undertake related party transaction, okay, I will not be referring to section 188 of the Companies Act. and I will be referring to the provisions of the IBC, seeking creditors' approval, amending the constitutional document which otherwise is falling within the power of the shareholders to pass a special resolution for alteration of the memorandum and article. But here I would like to consider the provision of section 6, this 28 into consideration. Disposal of or permit disposal of the shares of any shareholder of the corporate debtor or their nominee. Again, I would like to consider the IBC over the Companies Act. Making any change in the management of the corporate debtor or subsidiary, I will be taking care of the provisions of the IBC. Transferring rights or financial debt or operational debt, I will be taking care of the power of the COC. Making changes in the appointment or terms of contract of such personnel as may be specified by the COC. Making changes in the appointment or contract of the auditors and internal auditor. Here it comes. I was referring to the section 28 subsection 1 clause M. Now, this is the provision which I was intending to share with you. Now, there is no such requirement that your earlier auditor, who was the statutory auditor of the company during the era when the company was in the complete control of the management of the corporate debtor, and his appointment was being made and his appointment was being approved by the shareholder at the AGM of the company prior to CIRP. But in case if you want to make some changes in the appointment or terms of contract of the auditor or the internal auditor of the company, you are supposed to take the COC's approval. And it is clearly stated that no action under subsection 1 shall be approved by the COC unless it is approved by the vote of 66% voting share, meaning thereby the views are very clear. When the IRP called the first meeting of the COC, that is within 7 days from the date of submission of the list of stakeholder to the adjudicating authority, with 5 days prior notice, he need to call the first meeting of the COC. If we want to continue with the same statutory auditor who was the auditor of the corporate debtor prior to CIRP, in that case, he may continue to do so with the approval of the COC. But in case if any change is being expected, if any change is being proposed, and if new person to be appointed as a statutory auditor, then considering the provision of section 28 subsection 1 clause M, which states that to make change in the appointment or terms of contract of auditor or internal auditor of the corporate debtor, it is mandatory upon the RP or the IRP, or I may say IRP or RP as the case may be, to seek the approval from the committee of creditors. I hope you got the point. Will appreciate your acknowledgement to the same, so that at least I can have that idea to proceed with the another one or to stick to the last one.
Yes, sir. You can proceed.
Yes, sir.
You can proceed, sir.
Yes, sir. So one more thing which I would like to add on to this connection. I've seen many applications wherein one of the statutory auditor I'm representing before the NCLT Ahmedabad bench. Now there was an application which is made against me under section 19(2). Against me, that is against my client who is the statutory auditor of the company during the course of a CIRP. So during the course of CIRP, I was appointed by the resolution professional with the consent from the committee of creditor. I was acting as a statutory auditor of the company. So there was a tussle between the RP and the earlier management. The question was pertaining to who will sign the financial statement. And of course, the financial statements are going to be signed by the erstwhile management. And as I said that it is their power which are suspended and not the duties of the SBOD. So suspended board of directors are still required to sign the financial statement, especially considering the fact that when CIRP was initiated in the month of December, it is from 1st April 2023, or rather 1st April 23 till December 2023, the company was in charge of the earlier management. And thereafter, when CIRP was initiated, it was RP who was in the control of the management of the affairs of the company. So the question was, who will be the person shall be duty bound to sign the financial statement? And in my opinion, it is the suspended board of director. The question is, unless the suspended management sign the financial statement, I don't have any say, or I don't have any control over putting my signature on the financial statement. And there is a decided case laws in this connection that the board of directors cannot escape from their responsibility or from their duties as far as the CIRP is concerned, because they cannot take an escape, or they cannot take this view that since the CIRP is connected, or since the CIRP is commenced, as the power of the board of director gets suspended, and we are not going to exercise such power, because this is very well falling within the part of their duties and not the powers. Yes, we may call it is the power of the board of directors to approve the financial statement, but this time it is more of your duties or more of your obligation, rather considered as a duty. But unless the management sign the same, or unless the RP will even sign the same, I will be, as an auditor of the company, will no longer, or we will no more be considered as a person responsible to sign the financial statement without the signature of the management. And in such circumstances, there is no purpose putting my name in section 19(2) application, because there is no element of non-cooperation in this manner. See, my point is very clear that auditor sign the financial statement only after the financials are approved by the management. Unless financials are approved by the management, or unless the tussle get resolved first, that who will sign the financials, whether the board or the RP, I will be no longer be considered as the first person to put his skin into the game. I will be the last person signing the financial statement, and the first person will be the one who was in charge in the management of the company during the course when company was not in CIRP, or else the person who was appointed as an IRP or RP should sign the financials for the duration of the CIRP. So it may be either RP or it may be either board, but not I will be the first signatory in such circumstances. In this connection, there is one judgment of NCLAT which I would like to share with you before we proceed further. Is the screen visible?
Yes, sir. Visible.
Yes, sir. So this is one of the judgment of the NCLAT. This is Mukund Chaudhary versus Mr. Subhash Kumar Kundra. The NCLAT has held that it is the duty of the suspended director of the CD to sign the financial statement of the corporate debtor during the ongoing CIRP. And my point is this only, that director should not escape from their responsibility. During the course of CIRP, this shall no longer be considered as their power, but this shall fall within their responsibility. And I would again like to say that it is their power which is suspended and not the duty which is coming to an end, which of course is going to come to an end when company will be going into the liquidation, but not before that. The appellants are the suspended directors of the corporate debtor, so they have moved an appeal. The respondent is the RP. NCLAT principal bench had disposed of the IA filed by the RP, that is NCLT New Delhi bench. They have disposed of the IA filed by the respondent, seeking direction to the appellant to cooperate with the respondent and provide signed copy of the financial statement. So that was the point of dispute. The appellant, being aggrieved by the order of the NCLT New Delhi, filed the present appeal before the NCLAT under section 61. So the issue which was before the Honorable NCLAT was whether the appellants, being suspended director of the CD, are bound by law to sign the financial statement during the process of CIRP. So the contention of the appellants, the suspended management, they have put their contention that the respondent, that is RP, has been in control of the management of the CD since the initiation of the CIRP against the CD, wherein the appellant has raised objection in the balance sheet dated 31st March 2021 prepared by the respondent and sought clarification for the same. Appellant pleaded that they have not inclined to sign the financials prepared by the respondent because of the objections to various entries in the balance sheet till the respondent provides justification and clarity regarding the entries. Appellant submitted that the adjudicating authority disposed of the application filed by the respondent without giving an opportunity, which is generally the only contention which the appellants do have. Appellant further argued that since the respondent has the entire control over the management of the CD, it is the respondent who has to act and execute all the deeds on behalf of the corporate debtor. Since the respondent is the competent person to sign the financials, the appellant being suspended director shall not be coerced to sign the financials of the corporate debtor. Addition to above, the appellants have challenged the correctness of the balance sheet prepared by the respondent and stated that the balance sheet prepared by the respondent has discrepancies and the appellants seek clarification for the same. Appellants have relied upon the circular dated 8th of 2020, that is a circular of Ministry of Corporate Affairs, according to which the RP of the CD is responsible for signing the documents of the CD in capacity of CEO in order to meet the protocol of MCA. Appellant pleaded that they, being a suspended director of the corporate debtor, are not responsible for signing of the financials. Respondent contended that the appellants, despite of several reminders and communication, failed to provide the signed financial statement. So that was the point. Basically, the dispute was pertaining to who will sign the financial statements. The respondent submitted that the books of accounts were prepared by the auditor that was appointed by the corporate debtor back in 2017. So again, the same point is coming, whether the same auditor will be continuing or the new auditor will be appointed. And as I mentioned, the provision of section 28, subsection 1 clause aim that if you are intending to change the auditor, it is required that the COC has to approve the same by passing a resolution with 66% voting shares majority. The draft financial statement and the draft audit report was sent to the appellants for their review and perusal. The documents were to be signed by the appellants who failed to undertake the same. The respondent argued that the signed documents were required for the purpose of enabling respondent to file the financials before the ROC. The respondent pleaded that the respondent has provided all the requisite document to appellant, but appellant did not cooperate. And this is the final finding of the NCLAT. In light of the submission of the appellant and respondent, tribunal observed that the court does not release the director from their duties. And this is the very important point. Duty get released once the company is in liquidation. And that is what you will find. When you see the provision of the liquidation, when you see the provisions of the CIRP, you will find the difference in CIRP as we have seen section 17. The provision of section 17, subsection 2, clause E, that states that the power of the board gets suspended. In the liquidation, the power shall cease, meaning thereby the submissions clearly states that the court does not release the directors from their duties being the director towards the company, merely suspend that power as the director and appoint RP for management of the company in CIRP. The tribunal, while addressing the contentions of the appellants, noted that it is undisputed fact the appellants had signed the financials of the corporate debtor for first 3 quarters. The tribunal further noted that the appellants were objecting to sign the financials of last quarter merely on the grounds of objectionable entries and requirement of certain clarification, even when the financial statement were prepared by the same auditor who was appointed in 17 by the same management. Section 19(2) is repeated. The tribunal further held that circular relied by the appellant is merely a procedure for filing the forms. Circular does not restrict the suspended director from signing the financial statement. The tribunal observed that the order passed by adjudicating authority is well reasoned and there is no need to set aside the impugned order. And this is finally said by the NCLAT that even though the appellants are the suspended director, it is a duty of the appellant to cooperate with the respondent and to sign the financial statement of the corporate debtor in accordance with the provisions of the IB code. So this is one of the ambiguity which was settled by the NCLAT, that even though the company is in CIRP, the management cannot take this as step that their power gets suspended, because now that is falling within their duties and no longer be considered as their power. Your views on the same? to all the learned RPs in ongoing CIRPs. Without a counter, I will not feel that there is a conflict in the provisions of the IBC and the code and the Companies Act. So one thing is settled, that unless I'm not signing, in spite of the financials are being signed by the management, I should not be dragged on this ground under 19.2 application. 19.2 application is only in case of non-cooperation. And this is not a case wherein I am non-cooperating. I'm not signing because this is not a stage wherein I'm supposed to sign. It is always, even if a company is going concern, it is a financials which is approved by the board. And once the financials are approved by the board, it is me who is going to conduct the audit and sign, will issue my audit report and sign the financial statement. So right stage will be post the signature is completed by the parties in dispute, RPs and the suspended board, but the things are very much settled. It's not the RP. RP is just a facilitator of the compliance, but wherever the requirements are there from the old management or the suspended management, they are bound to sign those financial statements, even though the company is in CIRP. And this is what I would like to again reiterate, section 17B of the IBC vis-a-vis section 34.2. Let's see the language of both these provisions. And this is this is something which is very crucial to understand, that things are only and only limited to the power of the board and nothing beyond that. This is section 17 subsection 2, which we are again reading for the sake of a better clarity, that from the date of the appointment of the IRP, and of course it is talking about the post admission of section 7, 8 or 9 application, 7, 8, 9 or 10 application. So from the date of appointment of the IRP, the management of the affairs of the CD shall vest in the IRP. The power of the board of directors or the partners of the corporate debtor, so I mean to say it is for the LLP, shall stand suspended, and those power shall be exercised by the IRP. Power shall be exercised by the IRP. To the contrary, when you see the liquidation regulation, or to the contrary, when you see the provision of section 34 subsection 2, let us see to that first. Provision of section 34.2. Section 34 subsection 2 clearly states that on appointment of the liquidator under this section, all the power of the board of directors, KMP and the partners of the CD, as the case may be, shall cease to have effect and shall vest in the liquidator. So this is the difference between the provision of 17B of the code vis-a-vis 34.2, and this section 34.2 talks about the liquidation, that once the liquidator is appointed, the power of the board which was suspended once shall cease to have effect and shall vest in the liquidator. I hope you got the point and you got the difference between the provisions or the language of the law which is used in section 17 clause B vis-a-vis 34 subsection 2 of the code. Your views on the same? Oh, there is a very relevant point which is always a subject matter of dispute, and that is always a subject matter of due diligence for every RPs when they invite EOI or when they evaluate the EOI. And that is a provision of section 29A. Let me reach out to that first. Section 29A. This is the 23rd November 2017 outcome. By the way of an amendment, this provision was brought in, and it has clearly stated that I shall not be considered eligible to submit a resolution plan. And before I submit a plan, I have to submit my EOI. So along with the EOI, I need to give an affidavit to this connection, to this effect, that whether I am eligible quad 29A or not. So person shall not be eligible to submit a plan if such person or any other person acting jointly or in concert with such person is, and you will find this, that is there in clause E. I'm talking about the provision of section 29A clause E, which talks about disqualification to act as a director under the Companies Act, the most debatable one. And it is going into the width of the entire 164. 164 itself is it is classified in subsection 1 and subsection 2 and then subsection 3. The people only confine their due diligence to the extent whether or what is the status of the particular directors then. Now, this is very relevant point, because when you invite EOI and when a person submit EOI within 15 days, you need to shortlist the EOI, and you need to first of all announce the provisional list of the proposed resolution applicant, and the one whose name are not in the provisional list, they used to raise their objections on the same. And then finally, you need to conclude the same with the final list of the resolution applicant, proposed resolution applicant. So you need to identify, you generally go by, or you generally rely upon the affidavit which they have given that they are eligible as far as 29A is concerned. But as far as your own due diligence is concerned, the provision of section 29A, and since our discussion is confined to the Companies Act, I'm putting the provisions of the Companies Act under 164 of the Companies Act before you all. Now, as far as the provision of 164 is concerned, it is very wide enough. Let me share the screen to share with you the provision of 164. Is the screen visible? Sir, you may interrupt in case if any concerns are there with regards to the visibility or the topic itself. When you see the disqualifications, when you see the provisions of the disqualification, it is all divided 164(1), and there are certain general disqualification. When I say a person is of unsound mind, I'm not so concerned on that. Undischarged insolvent, applied to be adjudicated as an undischarged insolvent. So I'm not into that. I'm going straight away. I'm going straight away to subsection 2, because I've seen many of the IPs who are giving a support services to the IRPs or RPs or IPEs. They are confined their due diligence only to up to an extent of the DIN number. That whether the DIN, if I'm identifying the DIN from MCA portal, whether any remarks pertaining to disqualification under 164 is reflecting or not. In middle of 2020s, in 2020, 21, 22, and prior to 2020, many of the companies in the name of shell companies, the ministry has taken an action and empowered the registrar to struck off the company's name. And those companies' directors have been marked as disqualified under 164(2). And several writ applications were made before the Honorable High Court of the respective jurisdiction, and they have got an order for removal of that disqualification for that company. So people are confining to their due diligence only up to an extent of what is the present status of the DIN, and they are not going beyond that also, because there is no source available to go up to a certain extent while doing the due diligence. The point here is, no person who is or has been a director of the company which has not filed financial statement or annual return for continuous period of 3 years. I myself has found many a times that a company which is in CIRP, the management of that company has not filed financial statement for more than 3 years even. But their status of DIN is approved. The status of DIN is indicating approved. But as far as the provisions of the law is concerned, since I have been appointed as an IRP, I'm aware of the fact that this company has lastly filed its financials in the year 17-18 and not at any time thereafter. Company was admitted in CIRP in the month of Jan 2023. So 17, 18, 18, 19, 19, 20 and years beyond that, the company's management has not filed a financial statement. Now the point is, who am I to qualify that person or to disqualify that person that is disqualified? Or I shall be waiting for a official affirmation or clarity in this regards from the ROC or from the ministry. So this is one point. So this is quite transparent, because this can be seen from the MCA portal itself. So from www.mca.gov.in, I can see this, and this is quite evident, or prima facie you can find the compliance or non-compliance. But going beyond that, clause B, fail to repay the deposit accepted by it or interest thereon, fail to redeem debenture on the due dates or pay interest thereon, failure in payment of dividend, and such failure to pay or redeem continue for more than 1 year. Now, how come I will reach out to this conclusion? Because unless a depositor or unless a debenture holder or unless an equity shareholder will approach the appropriate forum, this will not come into the knowledge of the regulator or the registrar to mark a person as disqualified, or this will not come to a knowledge of the court or the tribunal to mark any person as disqualified under 164 subsection 2 clause B. You're getting this point? Now, this is the most controversial point, because if I have been appointed as an IRP and RP, and if I want to identify clause A, I can identify from the MCA portal. But now the ambiguity before me is, shall I confine my findings or shall I confine my conclusion to the fact that since the status of DIN is active, and I am no one to mark any person as disqualified? So that is one. And point number 2 is, how can clause B of subsection 2 of 164 can be acknowledged? And in such circumstances, I don't have any document to rely upon except the affidavit sworn by the deponent, who is the suspended management or who is the proposed resolution applicant. Your views in this regards are very valuable, especially the one who are practicing company secretaries or chartered accountants. So this is the most, and all these points which I'm raising are unfortunately not raised before any forum. from where we can get some clarity from the tribunal or the appellate jurisdiction or the apex court. I've not seen such kind of points which are being raised, and I exactly don't know. I'm surprised to see why not. Because in the majority of the CIRP, it is witnessed that companies' returns are not filed for more than 2 years or for 3 years. Then in that case, when it comes to the question of whether a suspended management can propose a resolution plan or not, okay, yes, they can, if they are qualified under 29A. Now, what in case if the financials and the returns are not filed? How I may consider them as qualified, and why I'm going to wait for the ROC or the ministry's official confirmation on its web portal that DIN, as per the DIN, he is not, or he is disqualified in 164. So my point is confined to 164(2) clause A and clause B. To please share your views on the same.
Sir,
To all the practicing company secretaries, yes.
Sir, in general practice, ROC stopped, blocking those DINs, no? So when we check MCA portal, we understand that there is a 3 years returns not filed. And
Sir,
we
I
can
will
take
request you, in case if you can please open your video.
Sir, is it clear now?
You are visible, sir. You are visible. You are driving. I must say that you please focus on driving. Otherwise, I will be held responsible for any incident.
No, sir, I'm parked somewhere. So,
Yes, sir. Please.
sir, the point is, MCA generally does the DIN disqualification list, but they have stopped it from last 3-4 years. They are not
That
doing
is what my point is, sir. That is what my point is. In the mid 2020s, they have done so. They have published the list of all the entities as well as the associated directors. And also, we used to find the same from the MCA portal in inquire DIN status, that what is the eligibility or what is the criteria or what exactly the status of the DIN. But my point is, why the only reliability is to an extent of the ministry's portal, and why independent views cannot be taken in this regards.
Sir, I
Yes,
feel it.
Vignesh.
Yeah, I feel is, sir, the moment we say 3 years returns are not filed, we are considering them as disqualified.
Absolutely, they are disqualified because there is no provision which states that even after the non-filing, they will be marked as a disqualified only by the regulator or only by the ministry. Absolutely. Someone else? And Vigneshji, what is your view in 164(2) clause B about non-repayment of mature deposit or non-redemption of debenture or interest thereon or non-payment of dividend in spite as declared? So from where to get this data?
Sir, only way is IEPF in case of dividend. Other cases, honestly, I don't think so. We have any clue to investigate. As you rightly said, taking some affidavit or undertaking is the only way, is what I feel, sir. Or maybe looking into that company data if it is available, if they are director associated somewhere. If not, there is no way, sir. And plus, if they have not filed the return, then the gone case. There is no way you can check.
Absolutely. And in such incidents, they should not be treated as if they are eligible under 29A. But since I've seen that why these points are not being raised by the COC, not even by the RP. I've seen in many of the cases, I'm confined to my discussion to the matters which I have dealt upon. But yes, I may be wrong in this connection. But my point is very, very clear that if the filing is not done, and this is what provided in 164(2)A, non-filing of the financial statement or annual return for consecutive 3 financial year, it will mark that person disqualified under 164 subsection 2 clause A. And once he is disqualified by the virtue of 29A clause E, he shall not be treated as eligible under the IBC to propose a resolution plan. Any other views?
Sir, don't you think this annual return non-filing is like a restricting the right of somebody to take over the business? For example, it is a natural right of somebody to do a business or carry out a business. Not just filing the annual return, you are saying that you are disqualified because the section says if you file the return, then disqualification automatically, gets resolved. So from that perspective, don't you think even though annual return not filed, you can't take a lenient view? Because your intention is somebody to take over the business and run. If they are able to do it, why you have to restrict them that just for non-filing the return, they are disqualified? But I
I
agree with
understand
you.
your views, but now this is something which I feel there is a lacuna in the Companies Act itself, because there is no provision which talks about removal of disqualification. Now, suppose if I have not filed a financial statement or annual return for 3 consecutive financial year, one day I found, okay, there is a disqualification which is going to be attracted. Let me file all the returns and will approach the ministry for removal of my disqualification. Now, in such circumstances, the point is there is no provision which is provided in the Companies Act which states that after making the offense good, my disqualification will be removed. I understand your point, but this is something which I feel that some amendment or some clarity should be brought in, that if it is a nature of the non-compliances which can be rectified or which is not undertaken because of the negligence on the part of the board as well as the concerned professional to whom the board has engaged. Now, suppose if it is not done, and belatedly if the same is undertaken with some additional fees or by making the payment of the penalty or by getting the offense compounded, there should be some provision which allows me to remove my disqualification. But unfortunately, it is not there. I have the views of other participants in connection with this point, which I have raised in 29A clause E, qua disqualification or ineligibility of the resolution applicant. You have any views on that? A very relevant point. I'm not doubting the integrity of any professional, but up to what extent the auditor shall be treated as an independent if the RP decides so to continue with the same chartered accountant or the same firm of chartered accountant who were acting as a statutory auditor even during the course of CIRP. Because in such circumstances, my only point is when the COC decide or when the RP frames an opinion for moving an application for avoidance transaction, this is equally important that you should see the audit report of those preceding years. You should see the audit report of the preceding years, more particularly with regards to undervalued transaction, extraordinary credit transaction, which is defrauding creditors. If the company's statutory auditor has not remarked upon, or if the company's statutory auditor has not commented upon, has not brought in the attention of the regulator or the authorities, and now when during the course of CIRP, if you are continuing with the same auditor of the company, of course with the consent of the COC, and today he is identifying the transactional auditor or he is identifying the forensic auditor and he is supporting the views, now he is questioning his own report which has been issued and signed by him in the past. May I have your views on the same? Why there should not be any bar in this connection? This is quite relevant to have a views of you as a practicing chartered accountant or practicing company secretaries or practicing IPs. What your take on this? Sir, please participate, and that is going to be the only way out we can able to brainstorm the subject, because only those issues are being raised which are required to be raised. I'm raising a genuine issues before you where there is no clarity. I'm not repeating with the same old topic of the waterfall mechanism under the Companies Act, which is 326, 327, vis-a-vis section 53, because this is all decided, this is all discussed. I'm not raising the issue of the compromise and arrangement or sale of the company as a going concern. So my point is very much confined to the issues which are required to be addressed. And my point was how much reasonable to continue with the same statutory auditor of the company who since years is acting as a statutory auditor when the company was going concern, and today when company is in CIRP, you are continuing with the same auditor. How much independentness you can able to presume or assume or anticipate or expect from the same firm? And the next point is, tomorrow when the COC will take this call, or when the RP will frame an opinion or will determine that, okay, let us go with an avoidance application, because today the opinion is framed that some preferential transaction or undervalued transaction or fraudulent transaction or extraordinary transaction should have taken place, and let us identify and let us unearth the same. Now, in that circumstances, if some extraordinary credit transaction were taken place, the statutory auditor would have been the first person who must have commented the same in its audit report by putting a clarify or by putting observation or by putting some remarks in its report. So when there was no such remarks in his own report, and tomorrow when he will be putting some suggestions that this is the firm of chartered accountant in Mumbai, let us appoint them as an auditor, as a forensic auditor or as a transactional auditor, that means he is questioning his own audit process. He is questioning his own audit report. He is questioning his own due diligence, or he is questioning his own functioning when he was acting as an auditor of the company. So my point is, how much reasonable or how much it is correct to continue with the same auditor, and why not a fresh firm or an independent firm which is not connected with the corporate debtor? Yes, sir. Please participate. And again, I'm repeating on the same aspect. Oh, see this. I'm sharing with you the regulation, a very recent, you can say, amendment on 18th of September 2023. And in terms of the auditor, this is the last one which was introduced. I'm on 30B, and this is Insolvency and Bankruptcy Board of India Insolvency Resolution Process for Corporate Persons, Regulations 2016, and I'm on Regulation 30B, which was very recently introduced with effect from 18th of September 2023. So just a year back. It was provided that any member of the committee may propose an audit of the corporate debtor along with the objective scope, estimate of the cost, time frame, and the name of the proposed auditor. The proposal made under sub-regulation 1 shall be considered as per sub-regulation 3 of regulation 18. An audit shall be conducted if the proposal is approved by the committee. The audit shall be conducted by insolvency professional having qualification required for audit. This is an opportunity for the chartered accountant who are the IPs. Because in the Companies Act, a statutory auditor has to be a chartered accountant, practicing member of the ICAI. Audit shall be conducted by the IB having a qualification required for audit. auditor shall prepare a report detailing his findings, and the same shall be presented before the COC along with the comment of the interim resolution professional or the resolution professional. Expenses shall be treated as a CIRP cost. So this is something which is brought in, and there must be some thought process behind the same. What are your views on the same? So my views are very, very strong in this connection, that there is no purpose going with the same firm as auditor of the company who undertake the statutory audit or who undertake the internal audit, because internal audit may not be an employee of the company, and there is no purpose when you are of the view on the one side that the power of the board of directors shall stand suspended. Then why not the role of the internal auditor gets suspended? The person has worked close with the suspended management, and if you are continuing with the same professional or with the same firm during the course of CIRP, what purpose is going to be served? Same goes with the auditor of the company. Since he was associated with the statutory or associated with the corporate debtor, to continue with the same firm, and especially in those circumstances when in the preceding year, last 2 years or 3 years, and in case of the fraudulent transaction, there is no look back period. So when none of his report is qualified, there is no remark, there is no observation, there is no qualification been raised in past. And in future, when you are unearthing the undervalued transaction or extraordinary credit transaction or the fraudulent transaction or the preferential transaction, if he is putting his suggestions before the COC, or he's recommending a new firm of chartered accountant or some other professional to conduct the transactional audit and forensic audit, up to what extent his own recommendation shall be treated as correct? I will appreciate your views on the same, but this was one of the topic for a discussion which was there in the top of my mind. Another relevant point with regards to the claims, I do consider that if there is a cooperation from the management, the RP will be, or the IRP will be at its very safe haven to verify the claim, which he is bound to verify within 7 days from the date of receipt of the claim. As far as the claim is concerned, it is required to be, you need to file your claim within 14 days from the insolvency commencement date, and within 7 days thereafter, the RP has to verify the claims. Now, my point is, if you are, see, this is very relevant point which I'm raising. Each and every point are not something which is subject matter of the Google. Here the point is, if you are receiving a claim from NBFC, or if you are receiving a claim from one financial institution, and the claim amount is, say, for example, 2.5 CR, he is putting his claim as a secured financial creditor. Please understand my question. You are acting as an IRP or the RP. You are acting as an IRP or RP. If you are getting the reasonable cooperation from the suspended management, you will be getting an advice what is fair or what is prima facie coming from a suspended management is a fair or unfair, but that you can see from his own intents. But let us not go into it. If you are getting a claim as an IRP, if you are getting a claim as an RP, and the person or the institution which has placed a claim or the company which has put a claim is putting his claim, filing his claim, the claims are being filed as a secured financial creditor. Now, what are the documents which are available with you to check the reasonability or the correctness of the claim? A secured financial creditor, I believe that is again the portal of the MCA which talks about the index of charge, because provision of section 77 of the Companies Act which states that the charge once created is required to be registered. I said when charge is created, it is required to be registered with the registrar of companies, and when charge get registered, the registrar of companies will issue a certificate of registration of charge. And the provision of section 77 is having overriding effect because there is no such provision in entire CIRP. Especially when a company is in CIRP, there is no conflicting provision, and the provision of section 77 will govern. I'm reading for the sake of convenience of each of the participant the provision of section 77 of the Companies Act, which states that, and I'm talking about that overriding provision, notwithstanding anything contained in any other law, for the timing in force, no charge created by the company shall be taken into account by the liquidator appointed under the IBC or by any creditor unless it is duly registered under subsection 1 and certificate of registration of the charges given by the ROC under subsection 2. For the sake of convenience, I'm reading it for the another time. The provision of subsection 3 of 77, notwithstanding anything contained in any other law for the timing in force, no charge created by a company shall be taken into account by liquidator appointed under this act or the IBC as the case may be, or any other creditor unless it is duly registered under subsection 1 and certificate of registration of such charge is given by the ROC under 2. Your viewpoints are going to be taken into consideration. You are an IRP, you are the RP, getting a claim from a company which is NBFC, getting a claim from a bank. They are filing a claim before you as a secured financial creditor. 2.5 CR claim you are receiving from that stakeholder of the corporate debtor, that creditor of the corporate debtor claiming itself as a secured financial creditor. You cross-verified it from MCA portal, www.mca.gov.in. There you find that index of charge. You are identifying the name of the same secured creditor, but the amount of charge which is registered is only confined to 50 lakh. Your viewpoint is the same. I will appreciate your views on this point because, again, this is untouched. I'll be happy to hear it from you that what is your stand in this?
Yeah, I'm not really sure, but I think the whole amount should be admitted because the provision you just read, that this thing is only for a liquidator. If you're an IRP or an RP, then probably, I'm not really sure. You may, whatever, even if you cross-verify with the MCA portal, if it's registered for a lower amount or not registered at all for that matter, then really, can you reject such a claim?
Sir, I first request you to please open your video so that at least we can interact. We are interacting for the first time, and let's have.
No. Yeah, please.
Yes, I've got your point. So you as an RP or the IRP is going to admit the full amount.
I think so, yes, I should.
So my next question to you is, let's say this company is getting some resolution plans. Considering the hierarchy which is provided under section 53, one has to propose a plan in a manner so that it should comply with 53.
Right.
The standing of the secured financial creditor are before the unsecured ones.
Right.
The workman will be having the equivalent footing along with the secured financial creditors. Some or other one is going to be impacted because of this ambiguous figure, or leave that thing aside. The very relevant point would be, if you are giving the status of the secured financial creditor, in spite of having the lack of clarity in terms of an amount, the percentage of voting in COC will be largely impacted.
Right. Yes.
Are you getting my point?
Yeah,
so what is forcing you to admit that claim as a whole, especially when there is no conflicting provisions in the IBC? In the CIRP, I'm not touching upon the liquidation because liquidation regulation will be applicable in liquidation and not in CIRP. Because in liquidation, there is a provision.
Yes, in the
liquidation,
situation you
there is
can
a rule.
adjudicate the claim. You can adjudicate the claim. Whereas in if it's CARP, I mean, I don't think you have a power to adjudicate the claim. You have a power only to collate the claims. As long
Absolutely.
as the documents given by the whatever the claimant is satisfactory to the extent of the full amount claimed, I believe as an IRP or RP, you really don't have much of a leeway in adjudicating that amount of claim.
Absolutely, but you are not adjudicating the claim. What is prima
Mhm.
facie before you in the government web portal is 50 lakh. So of course you
Okay.
are going to question it before the claimant that what is the reason behind this particular claim.
Yes.
Correct.
Yes, I
So
should.
when
I
you
should.
will be
Yes.
getting an answer that this is
Mm.
registered with or this is registered under SARSAI. Now SARSAI don't have any role to play when again this CIRP. When you see a liquidation regulation, in
Yeah, the
liquidation
existence of a charge can
regulation,
be verified with
absolutely,
the
that is a
yeah.
regulation 21,
Yes. Yes.
wherein there are three ways from which you can able to verify.
Fact.
One is
Yes.
if the charge is registered with the ROC, or else if it is default which is there registered with IU, or
Correct.
else if it is registered under SARFASI in
Yes, sir. Yeah.
SARSAI.
Yeah.
So I am not touching upon that side since it
Mm.
is the ongoing CIRP matter. My
Mm.
point is you are going to counter it. That why the claim is being placed as secured financial creditor for a full amount of 2.5 CR if only 50 lakh or the charge is registered up to an extent of 50 lakh. So my point is what is going to insist you to get the claim admitted for full amount as secured creditor? And what about the inconsistencies or the question which are going to be raised by the other member of the COC later on or
Mm.
by the adjudicating officer itself?
I mean, I get your point. Obviously, these are relevant questions that I should ask. But depending on the reply, therefore, then I mean, then that I think will be the next step for you to, what do you say, to what extent you should admit that claim. But is there an option for me to admit part as a secured creditor to that extent, secured financial creditor, and for the balance is unsecured? Let's take for the opposite argument.
Absolutely. So,
See,
sir,
because
you
if
are a
I put
chartered
these points
accountant
and if
or you are a
the
company secretary?
I'm a company secretary. So
You're a
yeah.
company secretary. So you must be knowing 77.3 to
Yeah.
the practical aspects also, that what is the consequences and what is the non-consequences. Till date, I fail to understand why there is no PIL till date for the provision of 77, which clearly states that no registration would be possible after the expiry of 120 days.
20
But
days.
anyways,
Yeah.
not going into that debate right now. But my point is only an extent of that I'm getting a claim for an amount which is not disclosing in the official web portal of the MCA, and there is a variation
Mm-hmm.
in the figure. So, how much it is advisable to admit the full claim as a secured financial creditor? So, you rightly said that what can be done is, and this should be the only resort available with us, that you are not going to consider what is there with IU or what is there with the NESL, because there is a difference. Registration with SARSAI is a unilateral act.
Mm.
Again with the IU, many a times it happened that the IU are sending the email for seeking confirmation and it left unanswered.
Nobody answers. Yes. Yeah.
Absolutely, but this only happens in CHG1 when we file form for registration of creation of charge. Both the
Mm.
parties take this particular fact into consideration. Both the parties by signing, they affirm and they acknowledge and they agree to that registration of charge. Both
Charge.
charge
Yeah.
creator as well as the charge
As
holder.
charge holder.
So
Yeah.
both borrower as well as the lender. So I feel as far as the IBC is concerned, since in CIRP provision there is no clarity, I must say that only up to an extent of the charge which is registered with the registrar, you should consider that amount as a secured financial
Secure.
creditor. Other than that, the person should go as an unsecured. But it will not make any difference in the COC, because in the COC the voting rights are not
Yeah.
defined whether a
For
person is
unsecured
secured
and
or
secured.
unsecured. This
Yeah.
is only the problem which you may probably face when you are getting a resolution plan, because there
Yeah.
the dissenting, assenting, and the secured and secured will
Yeah. Yeah.
make some
What priority?
difference.
Yes. Yeah. Good.
Thank
Very
you.
valid points. Yeah.
I will appreciate in case if the other participants to have some contrary views so that we can prepare ourselves for the argument tomorrow. either the points which are raised by me are never been raised, or else this are already been answered in the previous session or somewhere by some other authors. But what I feel is the interactions are lacking, but I must say that that is the only thing from which we can able to accelerate the discussion. So this was one of the point, or this was one of the agenda which was in my mind to have with you. A very important point which I would like to share with you, and that is, till date I fail to understand why the suspension provision of 10A, the 10A provision which talks about that you cannot move an application if the default has occurred during that 10A period. That is March 25th, 2020 to 24th March 2021. I understand Section 7 application should not be allowed. Section 9 application should not be allowed. But what is a harm in allowing Section 10 application?
10.
See, if it is for the sake of protection of the corporate debtor, and when the corporate debtors management are willing to go for a CIRP, and the point is, it was the last business undertaken that was in COVID, and no business is undertaken thereafter. And my entire default period is during 10A only. Now see, my doors are closed. See, my doors are closed. If I'm opting for Section 271, Section 271, because of the enactment of the IBC, there is a deletion of the clause, inability to pay the debts.
Pay debts, yes. You no longer can go on the Companies Act.
I'm roaming around all the provisions of the law. Probably it may makes you discomfort, but yes, I must say that you will find in 271 of the Companies Act, there are certain clauses which are provided. And there is a deletion of the clause which used to call that in case of inability of to pay the debt, the creditor may move an application to the tribunal for liquidation. So today, the intent of the code is paramount, which states that if there is a case of inability to pay the debt, you cannot drag that particular company in the liquidation, and first you try and test the CIRP.
IBC, yes.
So here my point is, I cannot take the benefit of whatever is there in 271 because it is now deleted. On this ground of inability to pay the debt, I cannot liquidate my entity. Second one, since I am not an entity with no default and there is a subsistence of default, I cannot even touch upon the provision of 59 of the code which talks about voluntary liquidation.
So you need to be solvent, yes.
Because for a voluntary liquidation, there is a declaration of solvency which is required to be filed with the registrar of companies immediately after a board meeting, which is concluding that yes, we want to go for a voluntary liquidation prior to taking shareholders' approval. So that declaration of solvency, you will not be able to, you can say,
give the declaration,
treat yourself eligible for that. Now, only point or the only recourse available with me is the CIRP. Though my intention is liquidation, but I need to first face the resolution heat. I need to face the expenses of the CIRP. I cannot force my creditor to go against me. I don't have any control. Unfortunately, the creditor against whom the default is made, they are not in a position to move that application because of the suspension or the prohibition period. Now, I myself want the resolution, or I myself want the liquidation. Why there is a debarment in Section 10 for the corporate debtor? Now, this is my question to the government. Before that, to the participants.
So obviously, I mean, since in this case, your intention is to go directly for liquidation, which cannot be done without the CARP, I think even the prepackaged thing won't make a sense because you don't have any plan in place.
So intention of
you don't have any plan in place to pay anybody. You just want to get it liquidated.
Absolutely.
Yeah.
And as I said that my intent is to directly go into liquidation, but I have my hands which are tied.
Yeah.
Participants, I will appreciate if you will correct me in case if I'm going wrong. So that was one of the point of discussion with you all, and it was, I would say, that was assumed by me that I will be marked as incorrect in all these questions. But I feel this is the legitimate questions, and you are quite convinced, or probably you are traveling in the same bus. I've came across one more assignment wherein the ambiguity was pertaining to getting the secretarial audit done. So there is a provision of section 204 which mandates certain class of companies to get their secretarial audit conducted by a practicing company secretary. Right. On turnover based, on paid up capital base. So in that company, the turnover once was 250 CR. In spite of having that turnover, the CIRP was initiated. No attempts were made to settle with the applicant. CIRP continued, but the question which I initially raised, AGM, the first question which was raised before me was for AGM. And the another thing is, before AGM, it is required for me to circulate the financial statement to the members. Since the Companies Act is purely not touching upon this aspect, I was bound to comply, because as I said, that section 17, and that is section 17(2)(e), which is giving a warning to me as an IRP that I will be held responsible for compliance. Yeah. Being a company secretary, I was very much conversant with what is there in 136, or what is there in 96, or what is there in 137. But I was not aware that for what reason I'm going to call the shareholders meeting, for what reason I have to circulate the financials, how I will prepare the board report, who will sign the board report. And with board report, if I am not going to circulate the secretarial audit report, how much I am complying with the requirement of law, for which tomorrow the punishment, or tomorrow the heat of the regulator will come in my way. Your views, sir? Because that is nothing is adding on a cost to the CIRP. And this cost is going to be recovered from the poor financial creditors until a resolution plan is reached. And if no resolution plan is reached, tomorrow I will be the only person being cursed by them. So this is another question which I came across. Unfortunately, I found no answer in the Companies Act. And when I say there is no answer in the Companies Act, I make myself very sure that there is no amendment till the last 10:30 a.m. today in the morning. So when I say that this is a compliance requirement, whether I'm supposed to comply or not, Act does not giving me any exemption, neither the code. And if the Act and code is not giving me an exemption, for what reason I should be held responsible was 17(2)(e), which we read. And why should I face the consequences from the registrar in this case?
And for all you know, the secretarial audit may be a qualified one.
Absolutely.
Yeah.
So this is again an issue which is required to be addressed, because more of a session, this is a point which we are actually preparing to place it before the government, a kind of suggestions or a guidance note. One more thing, independent directors and the non-executive directors during CIRP. And even their act prior to CIRP, up to what extent they will be held liable or they will be held responsible. I'm confined to the category of director. I'm talking about only IDs and NEDs. Non-executive directors, I'm talking about independent directors. I'm even talking about those directors who are nominated by the same member of the COC who are right now the members who are financial creditor. They have appointed their nominee director. In that case, if I will go back to the PUFE transaction, how or up to what extent I will be going to place it before the same or parallel line with the other directors. So this is again a point which is of the deliberation, and I must say that you please bring your views on the same.
I mean, I'm not really confident on that, but I think in so far as it relates to what do you say, the check bounce cases or other things, I think jurisprudence there is a bit clear. As long as you're not in charge for the day-to-day management of the affairs, under 138 cases, you can't be held liable. So to that extent, the NEDs and IDs are saved. But like you rightly mentioned, to the I mean, in case of PUFE and to circumstances itself leading to the CARP, I mean, to what extent you can hold them liable? I mean, probably unless see. So there is no sort of presumption in these cases. So, I mean, going by the basic jurisprudence, shouldn't the burden of the proof be on the person who is alleging that a particular person is liable? So, as far as violations of various statutes goes, I understand because the law casts deeming, what do you say, guilt on them, saying that if you violate, then every director or, I mean, the person in charge of the affairs of the company, they are held liable. But so far as other acts are concerned, which are not statutory violations for which a penalty or consequences already been prescribed, unless you can pinpoint and the acts as being attributable to particular director or set of directors. Um, I mean, I
No,
think
I'm
there.
going beyond. I'm going beyond. Their role is very significant when we say the
Decision.
transactions with the related parties. Audit
Yeah,
committee
because
plays a significant role.
yeah, these guys are the ones
Majority
who are
of the members of the
yeah,
audit committees are independent.
independent directors. Yes.
When they have not questioned the transactions in the past,
Mm.
today the same questions are being raised with
By
regards
the
to those
forensic. Yes.
transactions which are basically flown from their own heads, their own consent were given. Today, just because of they are holding the position of IDs or the non-executive director, and they
Mm.
are seeking a leniency in terms of the decided judgments in 138. I must say
Mm.
both are different things.
Yeah.
138 is something which is having no relevance when I say a related party transactions of the past, which are now being questioned by the COC itself. And the same person of the COC who was sitting in the boardroom, who was
Has
having a seat in the boardroom as a nominee director, he
has given the
himself,
rubber stamp. Yeah.
absolutely.
So I mean, so right. I mean, it's a bit tricky to answer, but so let's look at it this way. Should I be held liable because I gave my approval based on the facts and circumstances that were presented to me at the time of approval? Right. See, when I make a decision or when I say yes to a particular resolution in a meeting as a director, obviously I make those decisions based on the documents and information presented to me and based on the questions I asked based on those documents. So let's say at that point of time, I was satisfied that it was indeed a genuine related party transaction for the benefit of the company. And therefore, I gave my approval. And there's nothing to the contrary to show that I did not exercise due diligence at the time of giving my approval as an independent director, then I think in that case, I mean, I definitely should not be held liable. So therefore, it goes
But
back to the
your role
question
was
is,
not
if you are
only,
alleging that I am liable, the burden of proof is on you to demonstrate that I did not exercise due diligence as an independent director at the time of giving the approval to that particular transaction.
so again, to counter the same, my point is it was not only the approval up to an extent to which your power was confined. Giving the approval, your role was also to oversee the execution of those transactions. Let's say an extraordinary credit transaction. The company has accepted a loan in a very hefty interest rates. The interest was being transferred to the company's own related party. With what sense of mind they have given a consent initially, but now the point is whatever was conveyed to you and you have consented with all due diligence, all due care. Tomorrow, when it was identified before you, because that was a thing which was coming on since months, since years, you have never questioned that transaction. And tomorrow, the same transaction is being questioned by the committee of creditor, and now you are of the view, yes, those transactions were not legitimate or were not reasonable. To safeguard your skin in this game now, that will be difficult.
No, it is not possible, right? I mean,
Absolutely.
like you mentioned, if I myself now am feeling that they are not conscionable or they are, I mean, very hefty interest rate, then obviously I have not exercised my due diligence in my position as
Absolutely.
independent director. So why should I be let to go scot-free?
Absolutely. So that was one of the point which I was willing to have your views in this regards. One more point is in connection with This is the post-CIRP matter. Generally, I've seen in the resolution plan, several relief and several concessions are being prayed before the Honorable Adjudicating Authority. And Adjudicating Authority generally grants such suspension if it is falling within the ambit of law. One of the issue which I was facing as a company secretary in practice and not as a lawyer, and that was to implement the plan in terms of compliance. So generally what happens, once the resolution plan is approved, you need to communicate the approval of the plan to the registrar, and there is a reporting which is required to be made in form INC 28. So it is a prescribed form in which I am going to communicate that this company is now out of CIRP, and kindly change the status of the company on the MCA portal, which is shown as under CIRP. You need to mark it to active. So that is one thing. Second thing is, I need to appoint the director of the resolution applicant, the director which is proposed by the resolution applicant in its resolution plan. So as far as the appointment is concerned, this is not a troublesome process, because from the signature of the registrar or by the regional director, one digital signature gets, or one signatory gets added. Now my point is, to an extent, you don't have any access to the suspended management. You don't have any access to the suspended management. I don't find a resolution applicant knowing a suspended management when there was no access or there was no point of communication between a suspended management and the RP himself. So to remove them from the signatory on the MCA portal, there is no law which states that they have resigned. Absolutely, the law is only confined to that power gets suspended. And when company is now in the hands of the new management, qua a resolution applicant or a successful resolution applicant, to remove them from system is a process which can only be undertaken by filing a form which is prescribed for the said, and that is a DIR 12. I cannot call it a resignation. I cannot call a removal. I cannot call a vacation even. And there is nothing which is called as the power gets suspended and hence removed. This is again a point which require some viewpoint.
You are talking about the situation after the SRA takes over, right?
Absolutely. So after SRA is taking over the company, you and me have been appointed as a director, what was proposed in the resolution plan. Now there are 7 odd person who are still showing as a signatory. The problem, the realistic problem is, when I am approaching a new banker for opening an account, they will only rely upon the situation presently available on the portal. They will be insisting me to get the signature of all the person who are on the board. Now my problem is, the IBC law is not known to that level of the banker who is opening my account. And the time when it reaches to the legal head of the bank, much of the water goes out of that river. So my point is, how to remove them? May I treat this as a resignation or removal or vacation or disqualification, or how to treat this practical issue? This is one of the concern, having no correlation between the code and the act.
Was not that change introduced in DR 12? I mean, I don't remember.
Up to an extent, I am aware of, there is no such thing which is prescribed.
No, nothing. Okay. So, I mean, I don't know. Should we get a specific finding or a prayer at the time of approval of resolution plan that the management will be taken over and these guys will no longer continue as a director, and use that order to file as a removal?
So that is something which we are going to pick out of whatever is most comfortable. But now this is the point which is unaddressed till date, and there is no clarity which is provided in the code.
Yes.
One more thing. In one of the case which I lastly handled a few months back, the management has proposed that post approval of this plan, and fortunately they have got the plan in their hand. So their plan was approved. They were the SRA, approached me So
Okay.
since the corporate debtor was from Ahmedabad, that is falling within the jurisdiction of Gujarat ROC in Ahmedabad, they have mentioned in the resolution plan that the company will be having its registered office in Mumbai.
Okay.
So by the virtue of the plan, first of all, they were adamant enough that ROC should straight away give this effect in the portal itself, that ROC Ahmedabad to ROC Mumbai. I said this cannot be possible. You need to comply with the procedure prescribed in the law. And for that, there is a company incorporation rule, that is rule number 30, which talks about shifting from a state to state.
State to state, yeah.
So we complied with the procedure. Now the question which was emerged thereafter, in the entire process, you need to seek the creditor, rather approval, but you need to serve a notice to the creditors.
Creditors, yeah.
There is a requirement in section in the rule 30 sub rule 5 that after giving a newspaper publication, I need to notify my creditor about the shifting. And you know that resolution plan is implemented over the period of time, 90 days, 120 days, and the payments were not made at that time. I was knowing the moment I will be approaching creditor with this regard or in this connection, I will probably get one more application, interlocutory application against me in the NCLT. So what clarification I have given to the registrar is, or to the regional director is, they are the creditor who themselves have approved the plan. They were aware about the plan and they were aware about the content of the plan, that post approval of the CIRP, the registered office is going to be shifted and there is no purpose to notify once again. ROC has given me the answer in my own manner. In the same way I explained, they said that since they have already approved the same, there is no harm to send them a notice. ROC was very clear in connection with what is prescribed, you are complying. Today, when you are calling a shareholders meeting, you are filing the relevant forms, you are giving a public notice, then there is no harm serving them a notice through post or through mail. I said, sir, if I will be approaching them, probably we may get some revert. And I'm hopeful we are going to get a positive revert. And he said that there is no purpose waiting for it. Give them a notice. Now my point is, frankly speaking, they are the creditors of the new management now. Rather, they are the creditors of the corporate debtor, a corporate debtor which is now being controlled by the new management. So yes. I cannot take a step back that they are the creditor of the old management. Leave management, it is the creditor of the company which is right now being managed by you.
Yes, in the same company, yes.
So the point is, if the same creditor who consented to my plan, which states that approval of the plan, I will be relocating my registered office to Mumbai, is I'm supposed to approach them again or not? And again, the clarity is missing, is not there. Of course, my IBC is not going to deal into the same, but the Companies Act should at least give some clarity in this aspect.
So, I mean, I have a very interesting point in this thing. Obviously, I don't do much of CIRPs. I do more of voluntary liquidation. So I just want to share one of these things. So obviously, if it's a company going into voluntary liquidation, once the resolution is passed, you file MGT 14 and the status on the master data gets updated automatically once the form is approved, saying under liquidation. But in case of an LLP going into voluntary liquidation, there is no MGT 14 filing or any other form for that matter requirement. So therefore, the status on the LLP portal still continues as active. And once I enter voluntary liquidation, I don't really think there's a need to file the Form 8, Form 11 LLP that you do every year. And for 3 years, if I don't file this, let's say the liquidation continues for more than 3 years, so those designated partners or directors are disqualified. So now I've been behind IBBI to get this master data updated because I filed the latest master data correction form with the MCA for this LLP. And then they said, as per this circular, we can act only on the instructions of IBBI. Therefore,
absolutely. And there is a circular. Yes, there is a circular.
So I approached the IBBI saying that this is the response of the ROC. No, you please communicate to the MCA or ROC saying that this master data needs to be updated. So I get a call from the IBBI. So I explained to them what the problem is. So their first question is, sir, have you filed MGT 14? Then I patiently explained to the gentleman on phone saying that it is under the Companies Act. So that is not applicable for LLP. So there is no question of MGT 14. But the gentleman questions me saying that, have you tried filing it? But so, I mean, I really did not have an answer at that point of time. But I've been following up by email and I have no success in that. And I have really no clue how to get that master data changed to show that it's under liquidation for the LLP.
So this is the same problem.
Yes.
The same problem in response to which I have received this circular from the ROC Gujarat. You can find this. This is 6th March 2020. And you will find this. The master data for change in the status of the company from active or inactive to CIRP or liquidation, or from liquidation to active, shall be effected on the basis of the formal change request form submitted by IBBI.
Yes.
So it is the IBBI who will be submitting that form, not to ROC, to e-governance MCA. That is headquarter.
They should.
Since this function has been centralized, the registrar of company shall not raise and forward CRF either to e-governance cell or to the service provider for the above mentioned purpose. IRP or RP or liquidator shall be responsible for filing anyways. We are not on this. But the point which is raised in this connection, this is the same circular which you are referring to. And that is of 6th March 2020.
Yes. After this, the form INC 28 and MGT 14 were amended to include specific this thing. Because before this circular, we were filing under for voluntary liquidation saying 433 of the, 484 of the Companies Act. 484 of the Companies Act for voluntary winding up. And for INC 28, we were selecting another section. But these sections got incorporated into the form. So I think the IBBI is no longer forwarding requests to the e-governance cell because the MGT 14 INC 28s have now been enabled with CARP liquidation and other sections which get automatically. But for an LLP, so there is no mechanism. And in all earnestness, the IBBI should be forwarding this to the e-governance cell, but I believe they don't have any clue or they don't want to do it for whatever reasons. So my question is, these DPs are also directors in other companies and it's a very big MNC. So obviously, if their name shows up as disqualified for non-filing,
Absolutely.
8 and 11, it's very embarrassing and I'm really not sure.
And since you are handling the voluntary liquidation to a major extent, I have one more question in this connection. So companies in a voluntary liquidation with the approval of the shareholders.
Right.
And not only the shareholder, the voluntary liquidation regulation states that once you have received the shareholder's approval, ordinary or special as the case may be, you need to take the approval of the creditor within 7 days.
Yes, 2/3.
So you have received the creditor consent also. And much before that, you have filed a declaration of solvency, already identified the liability versus asset and the sufficiency of asset to indicate that liability will be paid. My point here is, you have given a public announcement within 5 days, which is prescribed in the regulations.
Yes.
And you will be waiting for, you will be waiting for 30 days for getting a claim. Now here, what is going to be your stand if the creditor, none of the creditor has filed their claim?
If none of the creditors have filed any claim, so I mean, in this case, obviously there is nothing written. It's all the way you go. So the way
this is a voluntary liquidation.
So the way I look at it is, if
you are aware that the liability is
there in the books,
is limited to an extent of the creditor from whom you have received the consent. They have not filed their consent. They have not filed their claim. Unlike what we do in CIRP, will the same practice be adopted in voluntary liquidation is my question.
Okay, so what I do is I take all the creditors as per the, books of account based on the liquidation commencement date. So it's not necessary that all of these creditors have given their consent for the voluntary liquidation because I require only 2/3 of them to give the consent to the voluntary liquidation resolution. And the second thing is, one is giving the consent, second thing is filing the claim. So irrespective of whether these creditors have submitted the claim or not, I admitted the claim. I admit a claim, or rather draw up my list of stakeholders, including these creditors under the relevant categories as stakeholders for them, because I already know the financial position. Now, for the need for me is to see if there is a person who has submitted a claim whose name is not figuring in the based on the records of the company in the books of account. Now, if that is there, that is when I'll have to adjudicate that claim based on the relevant record submitted by him, and probably it's a voluntary liquidation. So obviously you have the cooperation of the management also in this case. But if there's a creditor whose name appears in the books but who's not submitted the claim, I still admit the claim.
Meaning thereby, so you will not go and you will not wait for the payment as far as the claim is concerned. You will make the payment to the creditors which are stated in the company's books, and then you will go for a distribution to the equity shareholders.
Correct.
Okay.
So because there are columns that says amount claim, amount admitted. So amount claim will be 0 because they are not submitted a claim, whereas amount admitted will be X based on the books.
I will appreciate in case if you have some question, we should take it that in priority, or you have any concern to share, I will be more than happy to address the same.
Like I mentioned, it's mostly voluntary liquidations I do, so that's why I ran by the LLP challenge that I'm facing. Well, apart from that, I mean, not from my side, but if the other participants, I mean,
yes,
I'm sure they should.
One more interesting question which I came across few years back. Now the law is settled, but there was an application under Section 7 which was made against a struck off company. So the name of company was struck off at the time when the application was made, and the question which was emerged thereafter, that who will be moving an application for the revival,
restoring.
Right. So Section 7 application was very much with a singular purpose, that is to initiate CIRP. Prima facie, yes, for the sake of initiating CIRP, intent was to recover. But now the point was the status of the company was struck off. So from the records of the registrar, the status, the name of the company was removed. So the question which was emerged is, the opinion which was coming from across fraternity was that you in the capacity of creditor first move an application for getting the name restored. Now the question which was raised by the particular applicant was, who will bear the fees? Because revival indicates that you need to approach and you need to pray for activation, and you need to comply with the direction of the tribunal in this regard, which includes undertaking past compliances also. The second view was, let application be moved by the registrar of companies. But now the point is, why registrar will invoke the inherent power which is there in 252(1). And the third view, which was appreciated by many, that is, once the application is admitted, the company will be activated
automatically.
Absolutely. So this were the three views, but I will invite all the participants in this connection that what is your say, and then we'll see the NCLAT judgment in this regard. My question was, there was Section 7 or Section 9 application which was initiated against a company, a corporate debtor, the status of which was marked as struck off by the learned registrar of companies. The views were varied. Some of the opinion were that they should move an application for restoration of the company's name. Some other views were that let the registrar of company to move an application for activation. And the last view which was coming from few of the learned professional was, let the applications get admitted and let the company immediately upon admission of this application be restored to active. What is your take? And once you will come up with your opinion, I will be sharing with you NCLAT judgment, and now the law is settled. You can very well go against a company which is struck off, and such applications are being entertained and admitted by the adjudicating authorities. Let's have the judgment on screen. Is the screen visible? Yes. So the point here is there was a Section 7 application which was initiated against a company, and the company's data was struck off. So this is the fact. And the NCLAT has decided this issue long back, and today there is no ambiguity in this connection. Whether the application under 7 or 9 is maintainable under IBC against a company whose name is struck off from the register of companies. So this is, at the time, numerous questions arose whether a director and the officer liability in respect of the company that was struck off continued or not. And the Companies Act is very clear that even if the name of the company is struck off, the liability shall continue. Another question was, what about the asset of the company which were struck off by the ROC? And in this case, the recent judgment of the NCLAT Delhi in case of Hemang versus Greater Bombay Cooperative Bank Limited. So this Greater Bombay Cooperative Bank Limited moved a Section 7 application. The question that arose for the consideration was whether an application under 7 or 9 of IBC for initiating CIRP can be made against the company whose name is struck off. The same question also arose in another one of the case in which the similar decision was held by the Honorable NCLAT, taking into consideration the decision in the previous case. So what had happened, the name of the company, Penguin Umbrella Works Private Limited, was struck off by the ROC under 248. However, one of the financial creditor of the company, and that is a Greater Bombay Cooperative Bank, filed Section 7 application for initiating CIRP, alleging default in repayment of the company of certain amount. The NCLT Mumbai bench in the case admitted the above application. However, one of the ex-director and the shareholder of the company preferred an appeal before NCLAT Delhi against the decision of the NCLT Mumbai in admitting application. The appellant stated that the company against whom CIRP was initiated did not exist, as the name of the company was struck off from the ROC under 248. So even if the name of the company is struck off from the records of the registrar, that will not absolve a director from the liability. And for the sake of realizing the liability, or for the sake of payment of the liability, this company still be considered as if the company is active or live. For reason for deciding the issue as to whether an application under 7 of the IBC could be initiated against the company whose name was struck off by the ROC, application will be maintainable or not, and NCLAT referred and analyzed in detail section 248, 250 and 252 of the Companies Act. That is the power of the registrar to remove the name of company. And as far as 252 is concerned, it is the power of the NCLT to restore the name of this company. This is the relevant point. 248 subsection 6. The tribunal stated that 248(1) of the Act gives power to ROC to remove the name of company in the circumstances mentioned therein. 248 subsection 6, which is very relevant, provides that the registrar, before passing an order for removal of the name, shall satisfy himself that sufficient provision has been made for realization of all the amount due to the company, and also for discharge of the liability and obligation of the company, if necessary, to obtain necessary undertaking. The proviso to above also provides that the asset of the company shall be made available for payment or discharge of all the liability and obligation, even after the date of the order removing the name of company. The tribunal stated that from the above provision, it was clear that the asset of the company shall be made available for discharging its liability. Liability of the director and officer continues. So even if the name of the company is struck off, they should not take this shelter as far as the liability of companies is concerned. They shall be held liable. The tribunal further stated that as per 248(7), the liability of every director officer shall continue even after the company is dissolved under 248, and same can be enforced as if the company has not been dissolved. Meaning thereby there is no purpose going back, especially in case of creditor. For restoration of the company, it's better to go before the tribunal directly under 7, directly under section 9 for initiating CIRP. Hence, the tribunal stated that though the above provision, it was clear that the liability of director and officer of the company continues even after the removal of the name of company, and the same may be enforced as if the company has not been dissolved. 250 is also clear. The tribunal further stated that 250 mentioned that where the company stand dissolved under 248, company shall cease to operate as a company, but except for the purpose of realizing the amount due to the company and for the payment of discharge of its liabilities. And this is what the concluding remark of the tribunal was, that it was held that the NCLT is empowered to restore the name of the company and all the other person in the respective position for initiating CRP under IBC within 20 years from the date of the name. So this is the only limitation, that you need to move that application within 20 years from the date when the name of the company is struck off. And of course, for you, the limitation aspect is sincere. So you will be approaching well within time. So such an act of the creditor to move section 7 application for initiating CIRP is maintainable even against a company whose status is struck off. The tribunal held that the above case tribunal has power to liquidate the company under the IBC. This is 248(8). For such company, directly liquidation application can also be made. However, as per the IBC, except voluntary liquidation, instead of liquidation, the first step is the timely resolution. Hence, the procedure of CIRP is to be followed in case as the proceeding is initiated under the IBC. In the above case, the name of company was struck off. The company could not file the application under 59. In such case, in view of the provision of 252(3), read with 248(7), the application under 7 and 9 is maintainable against the company, even though the name of company is struck off. So this was one of the aspects wherein the act is clear. From the very beginning, we were discussing with those agendas, with those topics where there is a lack of clarity. But insofar as this last point of discussion is concerned, there is an immense clarity which is provided by the tribunal. So this was one of the aspect. One more thing, and that is in connection with the inquiry, inspection, and investigation. But the law is very settled in this case also, that section 32A, which is already today on the code itself, that up to what extent the inquiry or inspection or investigation application will be continued by the registrar of companies, or the action in this connection which is taken by the Ministry of Corporate Affairs will be continued. So only it will be continued against the erstwhile management and not against the corporate debtor, especially in the case when the corporate debtor is shifted in the new hands upon approval of the resolution plan. Let's have a look on section 32A. The concern is during the course of CIRP and much prior to the CIRP was initiated, Section 206 of the Companies Act was invoked by the registrar, which deals with power to call for information that reaches to the next stage of inquiry, that further goes into the inspection, and that further goes into the investigation. The company was in CIRP. Company was taken over by the new person, the new management, who are a successful resolution applicant. Now, how come the action is tenable against the corporate debtor? Now, as far as the action against the old management is concerned, that will be continued. But as far as the action against the company is concerned, a corporate debtor which has already came out of the CIRP, how much that will be tenable is the question now. And that can be answered in 32A. This is the liability for the prior offenses. And as I mentioned, the action was initiated during or prior to CIRP. So before the application of Section 7 or Section 9 or Section 10 was admitted, the Registrar of Companies or the Office of the Ministry of Corporate Affairs have initiated the inquiries, have initiated the inspection, or the investigation was going on. Now, after the approval of the resolution plan, if the company is coming again in the hands of the corporate debtor, whether the action will be continued, and what in case if the company is going into the hands of a new management for a successful resolution applicant, whether the action of the registrar or the ministry will be continued or not. And the answer today is very clear. Upon the enactment of this Section 32A with effect from December 2019, notwithstanding anything to the contrary contained in this code or any other law for the timing force, the liability of the CD for an offense committed prior to the commencement of CIRP shall cease. Corporate debtor shall not be prosecuted for such offense from the date of resolution plan has been approved by the adjudicating authority under Section 31. If the plan results in, very important, if the plan results in the change in the management or control of the CD to a person who was not. So company is coming in the hands of the person other than the promoter or in the management or control of the CD or related party. Person with regards to whom the relevant investigating authority has, on the basis of material in its possession, reason to believe that he has abetted or conspired for the commission of an offense or has submitted or filed a report or complaint to relevant authority. Meaning thereby, if the company is being taken over by the promoter or in the management or control of the corporate debtor or related party, then action will not be stopped. And this is what 32A is all about, notwithstanding anything. And this is going to be the very important topic for the session which is going to be followed after this session. Notwithstanding anything to the contrary contained in this code or any law for the timing force, the liability of the CD for an offense committed prior to the commencement of CIRP, the liability of CD is using by this provision shall cease, and the CD shall not be prosecuted for such offense from the date of the resolution plan has been approved by the authority under 31. If the plan results in change in management or control of CD to a person who was not a promoter or in the management or control of the CD or related party, or the person who was not a person with regards to whom the relevant investigating authority has, on the basis of the material in the possession, reasons to believe that had abetted or conspired for the commission of an offense or has submitted or filed a report or the complaint to the relevant authority. Provided that if a prosecution has been instituted during CIRP against such corporate debtor, it shall stand discharged from the date of approval plan, subject to the requirement of subsection having fulfilled. Provided further that every person who was a designated partner of the LLP or officer in default of the company or was in any manner in charge or responsible for the corporate debtor for conduct of the business or associated with the corporate debtor in any manner, or who was directly or indirectly involved in the commission of such offence as per the report submitted or complaint filed by the authority, shall continue to be liable to be prosecuted and punished for such offence committed by the corporate debtor, notwithstanding that the corporate debtor's liability has ceased. So there is no immunity, which is very settled law to the erstwhile management. So this was one of the point as far as the deliberations or the discussion for today's session is concerned was required to be taken care of. And as I said, I'm concluding to a provision which is going to be the beginning for the new session, and that is 32A. Yes, I will appreciate the views of the participants. In case if you have any questions to be raised, I will be responding to the same question immediately. If some clarity is required out of the discussion which has taken place in last 2.5 hours, I'm going to share my views upon the same. So I will be appreciating your questions in this topic, in this regards, if any. We have 5 minutes left as far as this session is concerned, and I'm happy to invite your questions in connection with the subject matter. We'll be appreciating your views in this connection or any opinion with regards to the point which are relevant or connected with today's topic. Participants, your questions are being requested. So what I have not touched upon, which is settled as far as the Companies Act is concerned, is even if the liquidation order is passed, the company can be sold as a going concern, and still there is no clarity in connection with the provisions pertaining to selling a company as a going concern. There are provisions of the Companies Act which talks about selling off or disposing of the asset of the company, but there is no provision which states that selling a company as a whole as a going concern. So there is a clarity which is required to be inserted in the Companies Act, because in the IBC we have this provision of selling a company or selling a corporate debtor as a going concern. So there is a one aspect which is required to be taken care of as far as the ambiguity in the Companies Act is concerned. And another part is compromise and arrangement, which is always possible as the first alternative or as a first resort, even if the liquidation order is passed. But there is a law which is very settled, that if the promoters are not eligible as far as 29A is concerned, they cannot propose any scheme of compromise and arrangement. So these are the two aspects which are roaming around when we see conflicting provisions, or when we see any interlinkages between the IBC and the Companies Act. This two, apart from this two, the third point of discussion is the waterfall mechanism of the Insolvency and Bankruptcy Code vis-a-vis section 326 and 327. And Moser-Bear judgment has settled things already. So the provision of section 326 or 327, which is giving a priority in payment to the workmen dues, will not be applicable if the company is being liquidated out of the failed CIRP, that is in the IBC, or if a voluntary liquidation is taking place. So here the constitutional validity of the provision of 327(7) is very much safe, As far as the provision of 327(7) is concerned, it is very clear that this 326, 327 shall not apply if the company is being liquidated under the IBC, whether it is under the liquidation or whether it is under a voluntary liquidation. But if it is under the IBC, it is section 53, which is prevail over 326 and 327. If there is no question in this regard, I would like to sign out. I would like to conclude the session with a thanks to all the participants for a patient listening. And I must say that if any questions will come your way or from your way, I will be answering the same. Still, we have a time of 2-3 minutes. You can very well touch upon any part of the discussion with regards to the interlinkages between this code or conflicting provisions of the code and the Companies Act. You can raise any question if you have. If not, we should conclude the session. Thank you all the participants. Thank you Institute of Company Secretaries of India for once again giving me an opportunity to have an interaction on the subject matter, wherein many of the aspects which I touched upon is still untouched and the law still requires some amendment or some clarity so that the things which are unsettled should get settled, which ultimately impact CIRP effectively or positively. Thank you very much.
Thank you very much, sir, for sharing your thoughts and experience on the matter with us and all the participants. The session was very insightful and all the participants were interactive. Participants, if there are any questions, then you can ask. Otherwise, we will conclude.
Since no
So,
questions are received in the chat box, we can
Thank you
conclude
very
as
much, sir.
Thank you, ma'am. Thank you very much.
You are requested to please share the. Now there is lunch break till 2 p.m. Harmeet ma'am session will start sharp at 4. Harmeet ma'am, shall we start?
Yes. Yes, madam.
Good afternoon, everyone. Now we have the session on the topic interplay between IBC and PMLA and Competition Act. Now the session will be taken by Harmeet ma'am. Let me briefly introduce ma'am. Ma'am is IP, PCS lawyer and post consultant having almost 2 decades of industry experience in legal areas. She is presently designated partner with Triple R Insolvency Service Experts LLP, one of the largest IPs of the country. She is also post consultant and trainer. She is committed towards empowerment of women and to propagate the idea of gender equality. Academically, in addition to being IP, she is commerce graduate from Shri Ram College of Commerce and she is also an independent director. Now, ma'am, please start with the session.
Good afternoon, everyone. So I understand this is post lunch, and as all speakers say, I also say the same thing, that it is sometimes difficult to, be awake and be participative in the discussions. But those who have interest in the subject would definitely keep pace of the discussions going on. And I would request all of you and any of you, if you have any relevant experience to share, if you have any query, you can just pause me over there, interrupt me. It is okay to have a discussion. I am also part of you only. I am also an IP. So we can always have an interaction wherever you feel that there is a requirement of a discussion, or if you have anything to share. So from here, I'll start my presentation. So screen is visible.
Yes, ma'am.
Okay. So the standard disclaimer, the views are mine, generally copied from the law as such. And anyone having, let us first have the views, let me have your views on what do you think in the recent scenario, not in the recent, generally, what are your views on how the PMLA should be ranked? Where the PMLA or the government authority, for that matter, Greater Noida or GVAT, how they should be treated in the list of hierarchy and where they generally fall in as per Section 53. Anybody would like to say something regarding the position of government dues, authorities, the treatment thereof, and vis-a-vis the Section 53, clean slate theory, 32A, preamble? Anybody would like to say anything about any of these subjects? See, our topic essentially talks about IBC versus PMLA. So what supersedes? What overrides? Where is Section 238? Is there anyone participating? Can I expect someone to speak? What about Section 238? Rajinder ji? Or anyone? Anjali, we also had a session in the morning.
Yes, ma'am.
What time? 10 to 1?
Yes, ma'am.
Are these people too tired to speak? What? No one. Okay.
Participants, please interact with Pico.
So just
I
asking.
think all the participants have not come back. Some of them have only come.
We have 24. Out of that, 2 are you and me. So we have 22 people. So I was just asking about section 238 if somebody wishes to speak about it. So how will we set the ground today for PMLA versus IBC if we don't talk about it? What is, where does a PMLA stand and where is its position with respect to IBC?
238, ma'am, is the overriding provision under the IBC code,
Yeah.
wherein I believe that which says that the provision of the code will be applicable, notwithstanding anything inconsistent with any other provision in the law.
Inconsistent, right? So that is the key word there.
Right,
If there's an inconsistency, then you will consider IBC provision overriding the other law. Absolutely right. So what do you think? PMLA stands over there? Do you think all the pending matters where ED has powers to attach and they are still subsisting, they are persisting, they are continuing their attachments, they are not listening to you, they are not listening to AA orders, nothing is being done in those matters? Why and how they are getting that authority? If 238 is so clear, where does that authority come from? It is so clear. We are aware about that. Anyone is having any views on PMLA having the authority and exercising that, whether they are doing it correctly? Do they have actual powers in the law? Any law for that matter? Where is their authority coming from? Anyone who has dealt with a PMLA matter in their matters, in their IBC matters? Any of you?
I think, ma'am, the provisions, the PMLA, the proceedings are against the individual, I believe.
No.
And under the IBC talks about the corporate debtor. So
Okay.
maybe, I mean, I'm not clear, but maybe for that reason, the overriding provision, so far as that is related to the corporate debtor, does not lie with the proceedings under PMLA, which are against the individuals, maybe the directors or the individual promoters.
To some extent, you are right, but I will tell you the exact answer to my query, where I am coming from and where PMLA comes from, and what does the Act says, the PMLA Act. It is a strong legislature, and the writers thereof, the legislature behind that, they had their legislative bodies had something in their mind while they laid down that law, and that is a strict law, that is a very cumbersome, harsh law, because of which the authority that they derive from that is so harsh that they do not consider IBC, Kejriwal, unke samne koi bhi kuch bhi nahi hai. They are the supreme. How come? There is something in that law, which I'm going to tell you now, which gives them that supreme assumption of authority, right? So when there is an assumption, that supersedes the written law. So we will see how they clash and where we would reach by the end of this presentation. So I'm not telling you where I'm going to lead to, because that is my personal opinion, and I will welcome your opinions as well. But first, let us understand, what do the two laws say? So you are right up to an extent, and I'm liking the spirit of at least somebody answering and participating. So let's start with the theory, what I have for today. It starts with the preamble. So can anyone tell me what is fifth? What is the fifth number objective written in the preamble? It talks about balancing the interests of all the stakeholders, including alteration in the order of priority of payment of government dues. What do you think it means? What have people thought while writing this in the preamble? Alteration in the order of priority of payment of government dues. Anyone would like to say something about this? Let me tell you. Order of priority kahan se change hua? Originally, we had the previous law which talked about the SICA law, essentially provincial insolvency, etc. They had a payment mechanism wherein first and foremost the government dues used to be paid, and thereafter the other creditors, workmen, etc. used to come. So now this law essentially intends to bring down the hierarchy of the government dues to the fifth point in the section 53. If you see section 53, first is CRP cost, then is secured creditor workmen, then something else, and then the government dues come on the fifth point, E subclause. So how that has been posted there because of this objective of the code, this preamble. And this translates into understanding, we can understand the intent behind this. So intent was to bring them down. That is one. So from here, we can say that PMLA का मतलब है कि government में vest हो जाने वाली है property. ED is going to attach that and that will vest in the government. तो अभी government का राज हो गया उस property के ऊपर. They can sell and recover the money and take the realizations to themselves. तो फिर कैसे हुआ? CD का पैसा, CD की property, they had a reason to attach that, they attached and then it belonged to them. What if the company is going into CIRP? तो उसका भी पैसा और उसके भी assets वो लोग ले जाएंगे. So there is an inconsistency. Now let us see where we reach. What is laundering? So laundering is defined as the act of transferring illegally obtained money. So this is most critical part of this presentation today. If you wish to understand laundering, if you wish to actually understand PMLA, this is the most important part. Illegally obtained money through legitimate people or legitimate accounts so that its original source cannot be traced. That is the most important point of today's discussion. So I'll go through this in the subsequent slide. And this was first used in 1973. Prior to that, we don't have the usage of the term laundering, laundered on record. So this is the first recorded use that said suitcases stuffed with $2 lakh of Republican campaign funds, money being laundered in Mexico. That means we know, although the idea of washing money is much older, so this is laundered means in fact it is being washed. So washing kaise ho rahi hai? Money was illegally obtained. I mean that was a dirty money, black money, illegally earned money, but through legitimate people. तो वो wash हो जाती है और वो clear money, clean money बना दी जाती है. Clear assets खरीद लिए जाते हैं. Clear लोगों के through pass करवा दी जाती है. And thereafter it becomes a clean money. So it is essentially washing the money. PMLA is the Prevention of Money Laundering Act 2002. It was an act to prevent money laundering, to provide for confiscation of property derived from or involved in money laundering. This is also a preamble. For matters connected thereto or incidental thereto. तो इसका preamble सिर्फ दो है. या तो आपको मनी लॉन्ड्रिंग को प्रिवेंट करना है, या अगर नहीं प्रिवेंट कर पाए तो जो प्रॉपर्टी डिराइव हुई है फ्रॉम लॉन्ड्रिंग उसको कॉन्फिस्केट करना है. Whereas the political declaration of global program of action annexed to the resolution so and so adopted by United Nations ने हमको बोला, and political declaration adopted by United Nations General Assembly in 1998 called upon the member states to adopt national money laundering legislation. इसलिए it became important for us, it became necessary for us to implement the aforesaid resolution and the declaration to have the Anti-Money Laundering Act in the country. Therefore, we had this act. PMLA empowers certain officers of the Directorate of Enforcement. So what is the Directorate of Enforcement? We call it ED. To carry out investigations in cases involving offense of money laundering and also to attach the property involved in money laundering. So दोनों चीजें important है. Again, preamble से ही निकल के आ रहा है. Offenses of money laundering plus to attach the properties involved in money laundering. तो क्या होता है, खाली पैसा लॉन्डर नहीं किया जाता, उससे प्रॉपर्टीज खरीद लिए जाते हैं, ज्वेलरी खरीद लिए जाते हैं, कुछ भी एसेट्स बना लिए जाते हैं. तो दोज प्रॉपर्टीज इन्वॉल्व्ड इन मनी लॉन्ड्रिंग मींस properties acquired from that illegitimate money which is being shown as a legitimate money. So PMLA envisages setting up of an AA to exercise jurisdiction, power and authority conferred by it, essentially to confirm the attachment or an order or ordering the confiscation of attached properties. तो एक तो attach करना और फिर confiscate कर लेना. It also envisages setting up of an appellate tribunal to hear appeals against the order of AA and the authorities like director, FIU and IND. FIU कौन है? FIU भी जो crypto और जो digital money में deal करती हैं companies, they come under FIU. They get themselves registered under FIU. So FIU is financial intermediary undertakings. That is a wing of RBI, and it takes care of the registrations of the companies which intend to deal in the crypto and all that digital money. They provide platform for trading thereof or something. So all those are covered under this. So they are also appeals arising from there also goes to PMLA ka appellate tribunal. PMLA envisages designation of one or more courts of sessions as special courts or special courts to try the offences punishable under PMLA and offences with which the accused may, under the Code of Criminal Procedure, be charged at the same trial. PMLA allows central government to enter into an agreement with government of any country outside India. Now, this is so very powerful. This gives power to the central government to enter into an agreement with government of any country outside India for enforcing the provisions of PMLA, exchange of information for prevention of any offense under PMLA or under the corresponding law in force in that country, or investigation of cases relating to any offense under PMLA. Now, what is money laundering? We were talking about it. पैसे को साफ धो के कैसे किया जाता है? Money is laundered, it is being washed. The ultimate objective is integration. So how this integration is done? There are many different ways in which the laundered money can be integrated back with the criminal. However, the major objective at this stage is to reunite the money in a manner that does not draw attention and appears to result from a legitimate source. I'll tell you how. For example, purchase of property, artwork, jewelry, or high-end automobiles are common ways for the launderer to enjoy their illegal profits. The first step involves introducing cash into the financial system by some means. कैसे भी करके पैसा प्लेस कर दिया गया है. पैसा आया कहां से, उस पे हम सेपरेटली बात करेंगे. The source of money, the origin of the money को बाद में बात करते हैं. अभी हम सीख रहे हैं कि मनी लॉन्ड्रिंग होता कैसे है. So we will understand कि ये ऑफेंस कैसे बनता है. So first time कहीं से कैश आया, कैश की हिस्ट्री में अभी हम फर्दर स्लाइड्स में जाएंगे. The second step involves carrying out complex financial transactions to camouflage the illegal source. Now, that cash came from an illegal source, but it is being layered and multiple transactions are being carried out. इससे उसको ट्रांसफर, उससे उसको ट्रांसफर, वहां से यहाँ निकाला, यहाँ से वो ले लिया, वहां से वहां कर दिया. ऐसी कॉम्प्लेक्स ट्रांजैक्शंस की जाते हैं जिससे लेयर्स बिठाए जा सके, सो दैट इट इज डिफिकल्ट टू एस्टैब्लिश, टू ट्रैक द ट्रेल बैक. The final step entails acquiring wealth generated from the transactions of illegal funds. Now, those funds were illegal, लेकिन वो धुलते लेयरिंग बिठाते लास्ट में फाइनली जब उससे मर्सिडीज खरीद ली गई तो उसको वहां तक आते बीच में 5 और 7 स्टेप्स वर इन्वॉल्व, जिसमें मनी ट्रांसफर हुई, ट्रांजैक्शंस हुए. वो ट्रांजैक्शन से उसको लेजिटिमेट बनाने की कोशिश की गई, but originally the source of money was illicit or illegal. So that is the crux of money laundering. लॉ में क्या लिखा है? आई तो जस्ट टोल्ड यू द प्रोसेस जनरली कैसे लॉन्ड्रिंग करी जाती है. Section 3 of PMLA Act says whosoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime. Now, this is the most important word in this entire section. Proceeds of crime. Crime hona chahiye ek. Crimes have been listed in the schedule to the PMLA Act. Out of those crimes, किसी एक crime से वो पैसा निकल के आया होना चाहिए. So that is the proceed of that crime, including its concealment, possession, acquisition, use, projecting or claiming it as untainted property. तो तीन aspects हैं. One is proceed of crime होना चाहिए. Two is उसका concealment, possession या acquisition या use किया जाना चाहिए. And three is the projection thereof as untainted money. Just give me one moment. I need to take this call. If you can excuse me for one moment. Just one moment. Sorry to have I think sorry for that disturbance. So there are three elements of an offense under PMLA Act. One is the proceeds of crime. There has to be a crime out of which some realizations are made. Second, there is a concealment or acquisition out of those proceeds. And third, you are presenting it as a legitimate money, right? So that is the laundering. Explanation to section 3 says for removal of doubts, it is clarified that a person shall be guilty of offense of money laundering if such person is found to have, one, directly or indirectly, attempted to indulge or knowingly assisted or knowingly is a party or is actually involved. This is such a wide section and its explanation. Again, they are saying the same words again in the clarification and the explanation. In one or more of the following processes connected with proceeds of crime. Now, proceeds of crime is sacrosanct. In any way, directly or indirectly, you are related to it, you are involved in it. In what? In the concealment, in the possession, in the acquisition, in the use, in projecting it as untainted money, claiming it as untainted property in any manner whatsoever. If there is a proceed of crime and this all has been done, any of these six have been done, then the process or activity connected with the proceeds of crime is a continuing activity and continues till such time a person is directly or indirectly enjoying the proceeds of crime by its concealment or possession or acquisition or use or projecting it as untainted property in any manner whatsoever. So the person shall be guilty of offense of money laundering if any of these is happening along with the proceeds of crime. So one basic fundamental point is the proceeds of crime. So the person who answered my first query should be knowing that in case there is a fact established that proceeds of crime are involved, then no matter सीडी है, नो मैटर उसके डायरेक्टर है, एम्प्लॉई है, प्रमोटर है, शेयर होल्डर है, whosoever is the connected person or the CD, कोई भी इन्वॉल्व रहा हो, if the proceeds of crime are involved, then जो भी उससे खरीदा गया है, चाहे वो सीडी की लैंड एंड बिल्डिंग ही क्यों ना खरीद, चाहे कोई प्लांट एंड मशीनरी क्यों ना खरीदा गया हो, that all will be considered to be bought out of proceeds of crime if that is established, and that CD or the person behind that shall be considered guilty of offense of money laundering. Now, what is proceeds of crime? Proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense. Scheduled offenses जो इसके शेड्यूल में लिखे हुए हैं ऑफेंसेस, सो वो ही क्राइम माने जाएंगे. इसके अंदर कुछ क्राइम्स मेंशन्ड हैं इन द एक्ट एंड शेड्यूल टू द एक्ट इटसेल्फ. तो एनी प्रॉपर्टी derived or obtained by any person out of the activity under the scheduled offense, or the value of such property, or where such property is taken or held outside the country, then the property equivalent in value held within the country. अगर आपने बाहर एक प्लॉट खरीद लिया है, एक मॉल खरीद लिया है, या उसका कोई भी गाड़ी खरीद ली है, कुछ भी किया है, तो सिमिलर वैल्यू का एसेट इन द कंट्री विल बी कंसिडर्ड. मान लो मेरे पास 2 मर्सिडीज यहाँ पे है, पर मैंने एक बाहर भी लेके रखी हुई है, एंड बाहर वाला इज द प्रोसीड ऑफ क्राइम. प्रोसीड्स ऑफ क्राइम से मैंने बाहर खरीदी थी, तो मेरी यहाँ वाली मर्सिडीज को ईडी ले जा सकता है. For the removal of doubt, it is hereby clarified that proceeds of crime include property not only derived or obtained from the scheduled offense, but also any property which may directly or indirectly be derived or obtained as a result of any criminal activity relatable to that scheduled offense. So this is a typically legal concept जिसके अंदर इतना wide power दे दिया गया है PMLA के अंदर कि सबके घर में ईडी पहुंच जाता है. We are aware ना कैसे ईडी हर जगह पहुंच जाता है. Scheduled offense क्या है? The offenses specified under Part A of the schedule, or the offenses specified in Part B अगर the total value involved is more than 1 crore, या offenses specified in Part C of the schedule. In this matter, AA कौन होता है? ED is a domestic law enforcement agency and economic intelligence agency. इनका adjudicating authority कौन है? ED. It is responsible for enforcing economic laws and fighting economic crimes in India. Now, what is the punishment? Section 4 says, whoever commits the offense of money laundering shall be punishable with rigorous imprisonment for a term which shall not be less than 3 years, but which may extend to 7 years, and shall also be liable to fine, provided that where the proceeds of crime involved in money laundering relates to any offense specified under para 2 of Part A of schedule. So offenses, some offenses under Part A के paragraph 2 में listed हैं. The provisions of this section shall have effect as if for the words which may extend to 7 years can extend to 10 years has been substituted. For those very offenses which are listed in para 2 of Part A, which we are not going into detail now, उनके लिए 10 साल की imprisonment. Attachment of property involved in money laundering. Let us come to our section जो हमें affect करता है. Section 5 subsection 1, where the director or any officer not below the rank of deputy director authorized by director या deputy director authorized by director for the purpose of this section has reason to believe. Now these are most important words of this section. Reason to believe. उसको believe है, he मानता है, he has some reasons to believe on the basis of material in his possession. उसके पास कुछ ऐसी information और material आया है जिसके basis पे he has a reason to believe that any person is in possession of proceeds of crime, and such proceeds of crime are likely to be concealed, transferred, or dealt with in any manner which may result in frustrating any proceedings relating to confiscation of such proceeds of crime under this chapter. तो proceeds of crime तो है ही है उसके पास, but उसने उसको इस तरह से conceal करा है या transfer करा है या उसको ऐसे use कर लिया है, dealt with, जिससे कि उसका कॉन्फिस्केशन पॉसिबल नहीं है। ऐसा नहीं है कि प्रोसीड्स ऑफ क्राइम आए मेरे पास और मैंने अपने बैंक में एफडी बना के रख लिया कि आओ वो एफडी ले जाओ। नो, I have transferred that money, I have used that, I have concealed that, I have entered into multiple transactions which are making it difficult to confiscate the property made out of that proceeds. He may. Now, who may? The director or the deputy director may, by an order in writing, provisionally attach such property for a period not exceeding 180 days from the date of the order in such manner as may be prescribed. तो हमारे बहुत सारे लोगों के मैटर्स में ईडी ने या तो पहले से करी हुई थी अटैच या ड्यूरिंग द प्रोसेस भी अटैच करने की कोशिश की है, एंड इन सम मैटर दे हैव सक्सेसफुली अटैच्ड। वो 300 पेज का एक वो रीजन टू बिलीव वाला ये नोटिस भेज देते हैं एंड देन दे कम एंड प्रोविजनली अटैच योर प्रॉपर्टी। What is attachment? How is it defined? Attachment means prohibition of transfer, conversion, disposition, or movement of property by an order issued under Chapter 3, provided that no such order of attachment shall be made unless, in relation to the scheduled offence, a report has been forwarded to a magistrate under Section 173 or a complaint has been filed by a person authorized to investigate. Right? Or a similar report or complaint has been made or filed under corresponding law of any other country. Proviso. Notwithstanding anything contained in the first proviso, any property of any person may be attached under this section if the director or any other officer not below the rank of deputy director authorized by him for the purposes of this section has reason to believe, on the basis of material in his possession, that if such property involved in money laundering is not attached immediately, the non-attachment is likely to frustrate any proceeding under this act. तो उसके पास ये भी रीजन होना चाहिए, वो इमीडिएटली अटैच कर लेगा इफ ही हैज अ रीजन टू बिलीव कि अभी अटैच नहीं किया तो दैट इज लाइकली टू फ्रस्ट्रेट एनी प्रोसीडिंग अंडर दिस एक्ट. For the purpose of computing 180 days, the period during which proceedings under this section is stayed by the High Court shall be excluded, and a further period not exceeding 30 days from the date of the order of vacation shall be counted. So this is the impact of attachment. Every order of attachment made under subsection 1 shall cease to have effect after the expiry of period specified in that subsection, or on the date of an order made under subsection 3, whichever is earlier. So we are not going through this because we don't believe that this applies to us. But for the understanding, one must be aware of these sections because generally, in many matters, the PMLA does come into play. So the director or any other officer who provisionally attaches any property under subsection 1 shall, within a period of 30 days from such attachment, file a complaint stating the facts of such attachment before the AA. तो डायरेक्टर हैज टू फाइल अ कंप्लेंट, कंप्लीट कंप्लेंट, जो कि हमारे काफी सारे फेमस मैटर्स में वो फाइल ही नहीं कर पा रहे थे. विद इन 30 days they have to file a complaint with the ED, and ED shall file in the court of law in case the order is challenged. What happened in P. Chidambaram versus ED? The Honorable Supreme Court have examined the object and scheme of the legislation, wherein it was observed that Section 3 of the PMLA stipulates money laundering as an offence involving proceeds of crime directly or indirectly. Further, the Honorable Court observed that Section 5 of PMLA prescribes the power of attachment of the tainted property involved in money laundering on account of reason to believe. And since the legislation does not provide definition of reason to believe, the Honorable Court cited Section 26 of IBC. Section 26 of IBC says, if there are certain facts and circumstances which are enough to believe anything, there are certain facts and circumstances which are sufficient to believe anything, then we can say that that person has reason to believe. As per the IPC, all the offences can be judged on the basis of knowledge, intention, or reason to believe. All the offences. IPC में जितने भी offences हैं, they can all be judged on the basis of knowledge, intention, or reason to believe. So this is such a strong word. And if a director or a deputy director or an officer authorized by them has a reason to believe on the basis of material in his possession that this money is tainted money or this property has been acquired out of the proceeds of crime, so he has a right to provisionally attach your property. Adjudication. On the receipt of a complaint under subsection 5 of section 5 or applications made under subsection 4 of 17 or under so and so, if the AA has reason to believe that any person has committed an offense under section 3 or is in possession of proceeds of crime, it may serve a notice of not less than 30 days on such person, calling upon him to indicate the sources of his income. So most important is from where this money was procured, the earnings, the assets out of which or by means of which he has acquired the property which is subject to that attachment or which is seized or which is frozen. The evidence on which he relies and other relevant information and particulars, and to show cause why all or any of such properties should not be declared to be the properties involved in money laundering and should be confiscated by the central government. The AA shall, after considering the reply, if any, to the notice, the show cause notice issued under subsection 1, after hearing the aggrieved person and the director or any officer authorized by him, and after taking into account all relevant material placed on record before him, by an order, record a finding whether all or any of the properties referred to in the notice are involved in money laundering. So ED shall decide, it shall record the finding by way of an order. Where the AA decides under subsection 2 that any property is involved in money laundering, he shall, by an order in writing, confirm the attachment. So originally क्या हुआ था? Provisional attachment हुआ था. Now it is the confirmation of attachment. Section 5 subsection 1 talks about the provisional attachment. 17 and 18 talk about the seizure of account or freezing of the accounts, money lying in any account or something. Or the no further transactions can be carried out of those accounts. So 17, 18 deal with them. So this order under subsection under section 8 subsection 2 talks about the confirmation of attachment. ED shall record a finding to that effect, whereupon such attachment or retention or freezing of the asset or record shall continue during investigation for a period not exceeding 365 days, 1 year तक चल सकते हैं, or the pendency of proceedings relating to any offence under this act before a court, या उस offence के against कुछ proceedings चल रहे हैं under any court, or under the corresponding law of any other country before the competent court of criminal jurisdiction outside India, as the case may be, and become the final order, become final after an order of confiscation is passed under subsection 5 or 7 of so and so by a special court. Right? So section 8 jo hai, that confirms the attachment made provisionally under section 5. Where the provisional order of attachment made under section 5 has been confirmed under section 8 subsection 3, the director or any other officer authorized by him in this behalf shall forthwith take the possession of the property attached under section 5 or frozen under section 17 as may be prescribed, provided that it is not if it is not practicable to take possession of the property frozen under so and so, the order of confiscation shall have the same effect as if the property has been taken possession of. For example, it is a bank account or FDs or trading account or securities account. So it is not possible to take possession. So it shall have the meaning as if it has been taken possession of. So there shall not be any further transactions from them. It shall be seized for use by the original person in default. Where on conclusion of a trial of an offence, the special court finds that the offence has been committed, it shall order that such property involved in money laundering or which has been used for commission of the offense of money laundering shall stand confiscated to the central government. This is the next step. So first is the provisional attachment, second is the confirmation, third is the possession, fourth is the confiscation and vesting of that property in the government. Where on conclusion of a trial under this act, the special court finds that the offense has not taken place or the property is not involved in money laundering, it shall order release of that property to the person entitled to receive it. Where the trial under this act cannot be conducted by reason of death of the accused or accused, declared, proclaimed offender or any other reason or having commenced but cannot be concluded, the special court shall, on an application moved by the director or a person claiming to be entitled to possession of that property, pass appropriate orders regarding confiscation or the release, as the case may be, involved in the offense of money laundering after having regard to the material before it. Where a property stands confiscated to the central government under subsection 5 of section 8, the special court, in such manner as may be prescribed, may also direct the central government to restore such confiscated property or part thereof of a claimant with a legitimate interest in the property who may have suffered a quantifiable loss as a result of the offense of money laundering. So this is another angle to it. We also know the Contract Act and other similar acts provide for a legitimate buyer of a property who was not aware that these proceedings were going on, or the money or the property was bought from the proceeds of money laundering or a proceeds of crime. So if he is a legitimate buyer, he bought it at, without having knowledge of the crime, and he has paid the market value of that in consideration. So then he may get it from the special court. Now vesting aa gaya, vesting of the property in central government, where an order of confiscation has been made under subsection 5 of 7 or 7 of section 8 or section 58B or section 60 in respect of any property of a person. All the rights and title in such property shall vest absolutely in the central government, free from all encumbrances, provided that where the special court or the AA, after giving an opportunity of being heard to any other person interested in the property attached under this chapter, is of the opinion that any encumbrance on the property or leasehold interest has been created with a view to defeat the provisions, it may by order declare such encumbrance or leasehold interest to be void, and thereupon the aforesaid property shall vest in the central government, free from such encumbrances or leasehold interest. Section 71 says, okay, wait. The provisions of this act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force. So this gives absolute powers to PMLA Act, right? So we will remember this section 71 while we are talking on the other lines and while we are discussing which act shall prevail out of these two in case of inconsistency. Section 72 talks about insolvency. Any property of a person has been attached. Where any property has been attached or any appeal has been preferred to appellate. In case referred to in A, the person dies or is adjudicated and insolvent before preferring the appeal, or in case referred to in B, the person dies or adjudicated as an insolvent during the pendency of the appeal, then it shall be lawful for the legal representatives of such person or the official assignee or official receiver kaun hai? Hum RP, as the case may be, to prefer an appeal to the appellate tribunal, or as the case may be, to continue the appeal before the appellate tribunal in place of such person, and the provisions of section 26 shall, so far as may be, they apply or continue to apply to such appeal. Authorities entrusted for investigation. The ED in the Department of Revenue, Ministry of Finance, Government of India is responsible for investigating the offences of money laundering under PMLA. FIU, as I told you, Financial Intelligence Unit, India, under the Department of Revenue, reporting directly to EIC, headed by Finance Minister. FIU is the Central National Agency responsible for receiving, processing, analyzing, and disseminating information relating to suspect financial transactions. It is also responsible for coordinating and strengthening the efforts of national and international intelligence, investigations for pursuing the global efforts against money laundering and related crimes. The scheduled offences are separately investigated by agencies mentioned under respective acts. For example, police, CBI, customs, SEBI or any other investigative agency as the case may be. लेकिन PMLA के लिए ED है और FIU है. Process. So what is the process under PMLA? First, the attachment proceeding wherein property is suspected to be proceeds of crime are attached. Under Section 5 provisionally, 8 confirmation. Second, the prosecution of accused through a special court with the intended goal of punishment. So these two are the processes which shall be carried out under PMLA. Under PMLA, two proceedings run simultaneously. One is attachment and seizure of property by ED, and second is criminal prosecution by of the accused by the special court. Civil court not to have jurisdiction. No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which the director or ED or appellate is empowered by or under this act to determine, and no injunction shall be granted by any court or authority in respect of any action taken in pursuance of power conferred by or under this act. Appeal to High Court हो सकता है. Any person aggrieved by any decision or order of the appellate may file an appeal to the High Court within 60 days from the date of communication of the decision or order of the appellate, provided that High Court may, if it is satisfied that the appellant was prevented by sufficient cause from filing the appeal within the said period, allow it to be filed within a period of extended 60 days. Section 42 further says High Court, within the jurisdiction of which the aggrieved party ordinarily resides or carries on the business or personally works for gain, and where the CG is the aggrieved party, High Court within the jurisdiction of which the respondent, or in a case where there are more than one respondents, any of the respondent ordinarily resides or carries on the business or personally works for gain. Bar of suits in civil courts. No suit shall be brought in any civil court to set aside or modify any proceedings taken or order made under this act, and no prosecution, suit or other proceeding shall lie against the government or any officer of the government for anything done or intended to be done in good faith under this act. तो PMLA भी अपने आप में छोटा मोटा नहीं है, ये भी बहुत ही powerful law है. If you go through the wordings which I have just presented, I have only taken out few sections which show the power that has been given to the ED or the officers thereof. Applying the principles laid down by Supreme Court in Ambika Industries and L. Chandra Kumar, and considering the fact that the first court, that is adjudicating authority, is situated in Delhi and exercises pan-India jurisdiction, and that even the appellate tribunal is also in Delhi, the Delhi High Court would be forum convenience. However, ultimately, it is a petitioner's choice of forum that has to be respected, as has been laid down by Apex Court in a number of cases. Now comes our insolvency code. And let us have some discussion. Let us see how many of you are still awake. Tell me one thing. In case CRP has commenced and thereafter an order for attachment comes, provisional attachment. the Section 5 attachment ka order comes to you, what will you do as an RP? No one is interested? If CRP, I'm sure some of you must have gone through this position. You must have taken steps also. If CRP has already started, it has commenced, and then the order for attachment comes from ED, what will you do to save the properties of CD? Will you file an appeal? Will you write to them? Will you write a reply to them? No one? So let me tell you, if an order of such nature comes for provisional attachment under Section 5, so first will be the Section 5 and thereafter will be the confirmation by the ED under Section 8. So if it is Section 5, then you can always say that Section 14 is going on and they don't have a right to attach any properties now, since CRP has already commenced. If the Section 5 order, Section 5 notice belongs to a date prior to the commencement of CRP and Section 8 notice comes, then you don't have a say. तब तो बिल्कुल भी कोई भी नहीं सुनेगा आपकी PMLA authority के अंदर. But if Section 5 order comes, Section 5 का show cause notice comes, then you can always reply to that and then write to them regarding 238, 14, everything about the IBC, citing some court orders also. Thereafter, in case they do not listen to you, they proceed with that, and in 6 months, they issue the order under Section 8 of confirmation of the attachment. Then you can file an appeal with the PMLA appellate tribunal. So these are the steps to be taken by the RPs who are facing this issue. I hope some of you are listening to it and you will get benefited out of it, because I cannot see people. There are no videos on, nobody is participating. So we are all aware about Section 14. Now let us see what Section 14 has to say and where it protects us from PMLA. It says, on the insolvency commencement date, the AA shall by order moratorium. Institution of suits or continuation of pending suits or proceedings against the CD, right, in any court, tribunal, arbitration, or other authority. So this saves us transferring, encumbering, alienating, disposing of by the CD any assets, action to foreclose, recover, security interest, etc. Recovery of any property by an owner or lessor where the property is occupied by or in possession of CD. So this is 14 ka explanation going on. So they say that all the government authorities, sectoral regulators constituted under any law, any permits, registration shall not be expired. So this gives enough power to the RP. This is an exception. This is not applicable to our matter today, so I'm not going through them. What does moratorium do? Moratorium facilitates and gives space for negotiations. It gives the creditors and the CD the opportunity to apply their minds on the additional stress during the CRP. Additionally, it gives them the chance to deliberate upon the viability of revival of the CD. The declaration of moratorium is in process, prevents the company's assets from downfall, enabling the corporate entity to continue with its operations without the fear of judicial adversaries. Thus, the moratorium seeks to reinforce its legislative wisdom, that is providing value maximization. So, agar moratorium na ho, to anybody and everybody shall keep filing cases against you and continue the proceedings against you, impose fines against you, the CD, hinder the business, take away the licenses, stop the registrations, stop the electricity, ये सब कुछ होने लगेगा if moratorium protection is not given. But during moratorium, is the attachment of property allowed? कोई तो बोलिए. We have 25 people. Do you think attachment of property should be allowed in moratorium? No. Thank God, one person is awake. So even then, have you seen the cases where attachments are being made, orders are being passed? Yes. So are we dealing with the law correctly? Are we protecting the properties of the CD? Now, Arya ji was having a point here. He said the individuals should be targeted. So I agree with your point, because there are two proceedings being carried out simultaneously. One is the attachment of property. Second is to punish the wrongdoer. So wrongdoer is always a human being. Behind the company, there has been a person who has done wrong, who has brought that illegitimate money, right, and used it for purchasing a property or disposed it off in a manner, whatever. And that tracking is being done by the ED. Now they have, while making a trail, they have reached to a point that property belongs to the CD. So logically, PMLA has a reason to believe. They give the power under the law, they give the power, and that power flows from UN General Assembly ने हम पे impose किया है कि anti money laundering law इतना सख्त बनाना है, आपको इतना harsh और powerful बनाना है. There is no ifs and buts. There are no no power to the सामने वाला, the accused, to stop their attachment, right? So first 180 days अगर provisional attachment है तो है. He has a reason to believe he will attach your property. He will show cause, issue you a notice to show cause why it should not be attached and all that. So coming back to IBC, shall we just protect those assets even if we have come to know that they have been bought out of the proceeds of crime? Will we not go against the law of the land? My opinion, no. We need to protect the CD, and we have a special purpose to protect the CD. Our IBC says wherever there is an inconsistency, PMLA also had this clause under section 71, but our 238 is latest and it should prevail. And it says that we have a power, we have a duty to protect the assets of the CD. We should do all it requires to get the maximum value out of it. तो आपके SRA कैसे आएंगे? आप उनको क्लीन स्लेट कैसे देंगे? आप अपनी एसेट प्रोटेक्ट कैसे करेंगे from attachment? You will write a reply to them. Thereafter, even then, if they pass an order, yes, you are right, Gopal Swami ji. Person can be proceeded against, right? But they have a viewpoint. As per their law, they say that we have a right to attach the property. Thereafter, the property shall be confiscated, and then we will take the possession, and then the ownership rights will vest in the government. This is the law for them. But at the same time, one has to apply his mind, which I think some courts, etc., are not able to, because it is a central government against whom they have to take a stand. Therefore, the courts are reluctant to take a stand. But in some matters, I'll just go through one High Court matter where the High Court has actually taken the stand and said that PMLA, SHMLA kuch nahi hai. Agar IBC hai, then the buyer, the SRA, has to be given a clean slate and the properties should not be attached or vested in the central government. चलिए वापस चलते हैं. At least some people are participating. Thanks. So moratorium protects us for all these reasons. Now 32A, what is 32A? Clean slate. 32A says the liability of a corporate debtor for an offence committed prior to the commencement of insolvency process shall cease. Very clearly, it is writing that any liability of the CD shall cease, and the CD shall not be prosecuted for such an offence from the date of resolution plan that has been approved by AA if the plan results in change in management or control. तो अगर आपका नया management आ जाता है, तो that new acquirer SRA should not be punished for the offences committed by the CD or the old management prior to the commencement of the CIP process. So the change in management कैसे होना चाहिए? That the person is not a promoter or a related party of such person, a person with regard to whom relevant investigating authority has, on the basis of material information in the possession, reason to believe. यहाँ पे they have captured your PMLA. Even the person with regard to whom, वो person आपकी management में नहीं आना चाहिए. Again, the SRA should not be a related party to your existing management, existing persons, against whom the authority, investigating authority, has a reason to believe that he had abetted or conspired for the commission of an offence and has submitted or filed a report or complaint to the relevant statutory authority. और उसकी complaint भी file हो चुकी है. Right? वो जो first 30 days में complaint file होना था, this is talking about that, section 3 का complaint. Provided that if a prosecution had been instituted during the CRP process against such CD, it shall stand discharged from the date of approval of the plan, subject to requirements of this subsection being fulfilled. Every person who was a designated partner, if it is a LLP, or an officer in default, if it is a Companies Act, a company, or was in the manner in charge of, responsible to the CD for the conduct of its business or associated with the CD in any manner. कितना wide बनाया इन्होंने. Do we check at the time of taking the resolution plan? Do we check the 29A clause का due diligence in such a detailed manner? The definition of designated partner under LLP, officer in default under section 2 subsection 60 of Companies Act. Keep in mind, do check these sections and apply those tests when the SRA gives his affidavit. तो हम खाली 29A का एक affidavit लेके उस पे trust नहीं करेंगे. हम being the resolution professional, he has to check. Even at the time of submission of the resolution plan, he has to check under 29A whether he is a person related to the promoters or not. तो उसका इतना लंबा detail यहाँ से भी निकल के आता है, and you have to be very careful about this. Involved in commission of any offence as per report submitted or complaint filed by an investigating authority shall continue to be liable to be prosecuted and punished for such an offence committed. So this is your point, Mr. Arya. This is the point that person shall continue and CD's assets will be spared. CD will not be. No action shall be taken against the property of the CD in relation to an offence committed prior to commencement of CRP if where such property is covered under plan approved by the AA, which results in change in control of CD to a person or sale of liquidation assets who has not been a promoter or management or control of the CD or related party, or a person with regard to whom the relevant investigating authority has, on the basis of material in its possession, reason to believe that he had abetted or conspired for the commission of the offence and has submitted or filed a report to the relevant authority. So an action against the property of the CD in relation to an offense shall include the attachment, seizure, retention or confiscation of. So this explanation is also given under section 32A, and this is such a wide and important chain that was made to IBC just to protect the properties of the CD. And still our courts are not going through these. They are not giving due importance to this because of some importance being given to the to your PMLA Act, central government being involved. Therefore, the correct judgments are not coming out of this section. So this says that nothing in this subsection shall be construed to bar an action against the property of any person other than the corporate debtor or a person who has acquired such property through CRP or liquidation process under this code and fulfills the requirements specified in this section against whom any such action may be taken under such law as may be applicable. Subject to the provisions contained in 1 and 2 above, and notwithstanding with the immunity given under this section, the CD and any person who may be required to provide assistance under such law as may be applicable to such CD or the person shall extend all assistance and cooperation to any authority investigating an offense. तो आप चाहे बच जाएंगे, CD बच जाएगा, CD will be given as a clean slate to the SRA, but it shall continue to extend all assistance and cooperation to the investigating authority. So, can we take a break, a short break of 10 minutes here? Anjali, can we take a 15 minutes break maybe? If you allow.
Yes, ma'am, we can take
Yeah.
15 minutes break.
Okay. I'll just be back by 3:25. Thank you. So we start.
Yes, ma'am.
So the most important section for any governmental authority coming into picture during CIRP could be 32A. And this could lead to, saving a lot and resolving in true sense what IBC has ever wanted. The intent is to resolve, not to recover. Although that is a subject of debate everywhere, even the written articles debate about it so much that it has not been hidden how it's on the face of it we are talking about recovery and resolution, but if we are talking about resolution, then section 32A comes into picture, which has been not so carefully drafted, but still it talks about PMLA also. So literally you can go back to the words, you can talk about reason to believe, investigating authority, everything is just coming out of that act. So the interpretation, the impact is that there can be no attachment of assets of a company when it is undergoing a moratorium. The amendment is beneficial for the investors of the company as the illegal properties can be utilized to settle their claims. It also absolves the CD of all the criminal liabilities and all claims of seizure, attachment, confiscation, and retention of tainted properties. Thus, many academicians agree that the introduction of Section 32A has settled the position of law and has cleared that IBC proceedings will override the PMLA prosecution. It shows the intent of the legislature that an alteration in the hierarchy of government dues was one of the primary objectives of IBC. That I showed you in the preamble. It talks about alteration in the payment of government dues as one of the prime objectives. (32A) refers to a scenario that would arise after the filing of a resolution plan. Okay. If the ED is allowed to interfere prior to that, then no resolution applicant would be encouraged to submit a plan, since the properties of CD would stand attached already, and that would be a sacrosanct process: attachment, provisional attachment, then confirmation of attachment, then possession, then confiscation, then vesting of right in the CD in the central government. So that will ultimately render these 32A meaningless, and your entire IBC, your plan invitation, your plan approval, that will all go in vain. The provision does not provide what all regulatory bodies fall under the category of investigating authority. The issue that arises due to this vague definition is that whether an approved resolution plan can exonerate the CD from all the other criminal liability claims, such as check dishonor, security law breach, etc. Or one of the significant implications of this amendment is that it is not a permanent solution for any parties. The amendment protects from attachment till CIRP is completed. Once it is done, the ED can proceed with the attachment and thus leaving the company high and dry.
The insolvency proceedings would be of no use then. However, this said provision also provides an escape route to the
The management obviously has a financials of the company, and they have prior knowledge if there is a possibility of the company going insolvent. So taking advantage of this knowledge, they may commit the criminal offense like money laundering under the impression that they will get advantage of Section 32A. If they are successful and the plan is approved,
the illegal proceeds would be legalized. The provision is also not very clear as to the fact that what will be the solution if ED proceedings are already going on when the CRP begins. So that is an assumption that we have to understand, that during the moratorium period only, the ED proceedings shall stop and thereafter they have a right to resume. It is not very clear that whether the proceedings which were halted due to moratorium shall be continuing or not. Because PMLA shall come into force. They will say that we have a reason to believe that this property was bought from the proceeds of crime and now we have a right to confiscate. So that all shall come into play again.
See in what happened in some of the matters in T. Mohan Raj and others versus Shah Brothers is part. Honorable SC held that Section 32A cannot possibly be said to throw any light on the true interpretation of Section 14(1)(a), as the reason for introducing 32A had nothing to do with any moratorium provision. At the heart of the section is the extinguishment of criminal liability of the CD from the date the plan is approved, so that the new management may make a clean break with the past and start on a clean slate. A moratorium provision, on the other hand, does not extinguish any liability, civil or criminal, but only casts a shadow on proceedings already concluded.
Just a moment. Sorry. So a moratorium does not extinguish any liability. It just puts a halt on them. It only casts a shadow on the proceedings which have already been initiated and which can be initiated during this process. So once the shadow is lifted, when the moratorium period comes to end, the proceedings may initiate thereafter or resume thereafter. Also, 32A1 operates only after the moratorium comes to an end, that is at the time of plan approval. So 32A's goal is value maximization and need to obviate lower recoveries to creditors as a result of CD continuing to be exposed to criminal liability of the past deeds of promoter, etc. During the period prior to commencement of insolvency. So it has a separate purpose altogether, but it is not very clearly drafted. Unfortunately, it is inelegantly drafted. Honorable Supreme Court said that. The second proviso speaks of persons who are in any manner in charge of or responsible to the CD for the conduct of its business or associated with the CD and who are directly or indirectly involved in the commission of such offense. Which offense? That is the offense referred to in subsection 1. As per the report submitted or complaint filed by the investigating authority. So report submitted here refers to a police report under sections 173 and complaints filed by investigating authority and the special acts as opposed to the private complaint. So which complaint are we talking about? Which investigating authority are we talking about? If the proviso, if the language to the second proviso is taken to interpret the language of 32A in a manner that offense committed under 32A subsection 1 would not include offenses based on the complaint under section 2 of criminal procedure code, with the width of the language would be cut down and object of section 32 would not achieve, as all prosecutions emanating from private complaints would be excluded. Obviously, it cannot be read in this fashion and clearly includes the liability of the CD for all the offenses committed prior to the commencement of CIRP process. Doubtless, a section 138 proceeding would be included and would, after the moratorium period comes to an end, with a resolution plan by a new management being approved, cease to have an effect. Right? So 32A is not very clearly drafted and it is actually not really helpful. If one goes into literal interpretation and goes through the, yes, intent is clear that whatever liabilities of the CD were there prior to the commencement of the CIRP should not have an impact on the SRA. But people shall continue to be responsible. The assets and properties, although they are covered under subsection 2 of 32A, but the assets and properties will still they be considered as the proceeds of crime? Will PMLA get an authority back to resume the proceedings which were carried out before that period? So that is not very clearly written over there. Section 238 says about inconsistency. We are aware about the language, but we have also seen in section 71 of the PMLA Act, which talked in the same manner. The provisions of this act shall affect same language, same manner. Section 71 of PMLA Act also talks about the same. So both the enactments have this non-obstante clause. Both give a clear overriding effect to both the acts. However, Supreme Court in the matter of Maruti Udyog versus Ramlal held that if two special statutes have a non-obstante clause, the one which is enacted later will prevail over the previous older one. The reasoning for such a conclusion is that the legislature, while promulgating the latter act, had the knowledge that a previous act is which is having such non-obstante clause already exists. Other judgments which talk about IBC prevailing over other laws, there are many. There are so many of them, even at the apex level, at the Supreme Court level, some of them are listed here. They talk about IBC prevailing over the other laws. Now let's see section 71 of PMLA, which is prior in time, while 1432A and 238 of IBC are latest will of the legislature. So there is an express statutory provision in the form of 32A, which is based on a clean slate approach, which not only protects the new management from criminal liability for old offenses, but also takes out the assets of the CD from coercive action. The object of IBC is the effective revival. It is submitted that this objective shall stand completely defeated if the RP is not given the charge of the properties of the CD, and even higher damage if the RA is not given the complete business assets. Section 31 was amended in 2019 to confirm that once a plan is approved by NCLT, it shall be binding on all stakeholders, including central government and all statutory authorities. So, in case the plan is approved with having a clause stating that the assets shall be handed over back to CD, PMLA, etc., any attachment or encumbrance or encroachment over the assets shall not continue under any law whatsoever. So, that shall be binding on the on the central government also. The intention behind insertion of section 32A and 31(1) wide the amendment acts was to protect the assets of CD during CIRP or liquidation process, where an offense may have been committed prior to the CIRP. Thus, the true essence of 32A can only be appreciated by making this period, this process immune from any impediment, especially related to the past. Further, the code also envisages that the RA who acquires the rights in the CD ought to be able to enjoy the assets free from any obligation. That has been very clearly laid down in the Ghanshyam Mishra case. What are the other cases which emphasize the clean slate theory and which lead us to believe that PMLA and the powers they are under are subservient to IBC? One is Manish Kumar versus Union of India, where the court emphasized that a successful resolution applicant should start with a clean slate based on the approved resolution plan. Similarly, in Manish Kumar, it decided that it has extensively dealt with this section in context of section 32A. So it has given quite clearly and in detail about what 32A is intended about. No matter it has not been drafted very well, but the intent is very clear. JSW, the stand of the Ministry of Corporate Affairs was clear that the intervention by the ED or any such authority would have a negative effect on the entire CRP process. Telangana High Court in Satyam Computer Services said that after one wing of government, that is the NCLT, had induced a third party, like the strategic investor, to come to the rescue of a company, another wing of government, that is the ED, cannot take an action that will vitiate the entire process. So that is also a logic. Various case laws like PNB versus Deputy Director of ED, etc., etc., they also supported the CIRP for the benefit of all stakeholders involved instead of the attachment order of the ED. In Bhushan Power, what happened? The ED claimed that some of the assets owned by Messrs. Bhushan were in the nature of proceeds of crime. And hence, they had the power to attach the said properties. So JSW, the applicant, the resolution applicant, moved to the tribunal to seek redressal on the issue that plan has already been approved. The NCLAT ruled that ED will never have a claim on the property in the nature of operational debt. After the insertion of 32A, the NCLAT held that the resolution plan submitted by JSW Steel stands approved and the amendment provides blanket immunity to them, thereby flagging all the criminal prosecution against the CD. However, this decision was challenged by ED in the Supreme Court. A similar issue was faced by SEBI when it passed an order for attachment of assets. Subsequently, CRP was initiated against the company and there was a conflict. So the NCLAT held that due to Section 238, code will override the powers of SEBI and no attachment can be done by it. NCLAT held that in light of the above, the ED, while conducting investigation under PMLA, is free to deal with or attach the personal assets of erstwhile promoters and other accused persons acquired through crime proceeds, and not the assets of the CD which have been financed by creditors and acquired by a bona fide third-party resolution applicant through the CIRP process, and the plan is approved. Insofar as the RA is concerned, they would not be in wrongful enjoyment of any proceeds of crime after acquisition of the CD and its assets, as RA would be a bona fide asset acquired. RA as an RA would be a bona fide asset acquired through a legal process. Therefore, upon an acquisition under CIRP process by an RA, the corporate debtor and its assets are not derived or obtained through proceeds of crime under PMLA and need not be subject to attachment. So this has quite clearly laid down a clean path for the successful resolution applicant. The Union of India, on the other side, stated that after the completion of CRP, there cannot be any threat of criminal proceedings against the CD or attachment or confiscation of its assets by any investigating agency after approval of the plan. In any event, by virtue of Section 238, IBC has an overriding effect. Accordingly, it is clear that subsequent promulgation of ordinance is merely a clarification. Therefore, it is evident that the ordinance being clarificatory must be made applicable retrospectively. Shiv Charan and others versus adjudicating authority. Once a resolution plan is approved that qualifies for immunity under Section 32A, the NCLT has the power to direct ED to release the attachment. The statutory prescription under, so this is the latest judgment. I think this is quite recent one, the Shiv Charan wala, and this is very clear. They say that once plan is approved, NCLT has the power to direct the ED to release the attachment. Especially the assets of the CD cannot be considered to be proceeds of crime once the plan is approved because the RA has purchased them bona fide. The statutory prescription under Section 32A of the IBC means that no prosecution can continue against the CD and properties attached by the ED become free of attachment upon the approval of plan. The ED and AA under Section 8 of PMLA are under a constitutional duty to implement the aforesaid statutory prescription under Section 32A of the IBC. Although the High Court in its analysis does not refer to it, the decision is also supported by the terms of Section 31(1) of the IBC, which prescribes that an order of NCLT approving a plan is binding on all the stakeholders, including central government. What happened in Diamond Power? The resolution applicant has to comply the agreed payment schedule to the various creditors as stated in the plan. The RA submitted the plan being fully aware that the assets are attached and proceeding is pending. The RA is carrying the risk that in case his failure in implementing the plan, he would face consequences under Section 33, etc. The plan does not per se contravene any provisions of law as stated above. The plan is in compliance. Oh, I think one slide is missing in this. Now we have seen that both the legislations, PMLA and IBC, are special legislations in their own spheres which govern different aspects. However, if the CD and erstwhile management is involved in scheduled offences as prescribed under PMLA and proceedings have been initiated simultaneously to the CIRP, then both proceedings shall create friction. Due to certain situations where both PMLA and IBC should be applied, there is an uncertainty and lack of transparency as to how the provisions of both these acts should be applied. But I have understood with the clear interpretations given by High Court and Supreme Court in certain matters, especially in the recent one, the Shivcharan matter, Bombay High Court has very clearly interpreted Section 32A. Thereafter, there is no scuffle, there is no uncertainty or lack of transparency. I understand the procedure is set. Once you receive the order under the show cause notice under Section 3, you have to simply reply it back to it, stating that 14 is going on. Thereafter, if they issue any notice, any order under Section 5 of attachment, then you have to file an appeal. And if they do not consider that, then you have to go to NCLT, and thereafter the path is clear. On one hand, an argument can be taken if PMLA is not applied, then this would result in manipulation of the immunity and moratorium. Definitely, some of the promoters are using this immunity and moratorium to get away from the crime of money laundering. However, this argument is more academic. It has happened. I think this has been taken from somebody's article, but this has happened and people are taking advantage of this moratorium. Definitely, they are taking advantage. The other argument is that it hampers genuine business acquisitions and it affects the time value of money, and it can possibly make projects unviable as cases can linger on in courts for years. This is true. RAs are not coming forward where the property is under dispute due to PMLA or income tax or annuity. In ED versus Axis Bank, Honorable High Court of Delhi rejected the fact of prevalence of other laws over PMLA. They said PMLA was supreme. It was held that accepting moratorium and other immunity provisions of IBC would defeat the objectives of PMLA by opening an escape route for the offenders. A person indulging in money laundering cannot be permitted to avail the proceeds of crime, enjoy them, and get a discharge for the civil liability, as such assets are part of proceeds of crime and subject to confiscation. The provision relating to burden of proof in any proceeding relating to proceeds of crime under PMLA applies to proceedings before both AA with respect to attachment and criminal proceeding before the special court. So the AA here is the ED. तो आपको दोनों जगह पे burden of proof lies on the person, because there is a presumption of guilt. When the officer, who is authorized by the director or the deputy director and not below that rank, he has a reason to believe that there has been a procedure of crime which has been utilized for acquiring a property or which has been concealed. So there is the burden of proof lies on the accused. At two places, we are aware in PMLA there were only two objectives of that act. Can anybody share? Let's see who is awake. There are only two objectives of PMLA. No one is awake. Let me tell you. One is to confiscate the properties. They will vest in the central government to confiscate the properties which have been acquired out of the proceeds of crime. Second objective is to punish the wrongdoers, to punish the persons who have been involved in the crime of money laundering. So one is with the ED and one is with the special court. So the criminal proceedings go on with the special court, and the confiscation is with the enforcement directorate, which is the adjudicating authority under PMLA. So the legal presumption of guilt under PMLA is about the fact that proceeds of crime are involved in money laundering, which, however, can be rebutted by the person accused by producing evidence within his personal knowledge. Such legal presumption has reasonable nexus with the legislative intent of PMLA. Mr. P. Chidambaram, while introducing PMLA in the Rajya Sabha, in his speech said that we must remember that money laundering is a very technically defined offense. It is not the way we understand money laundering in a colloquial sense. It is technically defined offense. It postulates that there must be a predicate offense and it is dealing with the proceeds of a crime. That is the offense of money laundering. It is more than simply converting black money into white or white money into black. That is an offense under the Income Tax Act. This is not black into white. There must be a crime as specified in the schedule to the PMLA Act. As a result of that crime, there must be certain proceeds. It could be cash, it could be property, and anyone who directly or indirectly indulges or assists or is involved in the process or activity connected with the proceeds of crime and who projects it as untainted property is guilty of offense of money laundering. So it is a very technical offense. The predicate offenses are listed in the schedule. Unless there is a predicate offense, there cannot be an offense of money laundering. The Supreme Court on predicate offenses, in the event a person is acquitted in relation to the scheduled offense who rightfully owns or possesses an alleged tainted property, then such a property cannot be termed as proceeds of crime. The natural consequence of such understanding is that in the event there are no identified proceeds of crime, the authorities under the Act, being the ED, cannot step in or initiate any prosecution. Agar offense hi khatam ho gaya, to crime bhi nahi hai. If there is no crime, then the proceeds are not tainted. That is a legitimate money. While the whole quantum of a tainted property need not be regarded as a proceed of crime, the property qualifying under the definition of the Act will necessarily be treated as a crime property. In the matter of Nitin Jain of liquidator of PSL versus ED, it was said that it will be advantageous to summarize the conclusion reached by the above discussion. That is, the process of attachment, which leads to confiscation of proceeds of crime under PMLA, is in the nature of civil sanction, which runs parallel to investigation and criminal action. The empowered enforcement officer is expected to assess, even if tentatively, the value of proceeds of crime so as to ensure that such proceeds or other assets of equivalent value of the offender of money laundering are subjected to attachment. The evaluation being open to modification in the light of evidence gathered during the investigation. The empowered officer has the authority of law to attach not only a tainted property, that is to say a property acquired or obtained directly or indirectly from proceeds of crime, constituting a scheduled offense, but also any other asset or property of equivalent value of the offender of money laundering, the latter not bearing any taint, but being alternative attachable property or deemed tainted property on account of its link or nexus with the offense. So it gives so much wide power to the officer. If the tainted property respecting which there is evidence available to show the same to have been derived or obtained as a result of criminal activity relating to a scheduled offense is not traceable, or the same for the same reason cannot be reached, or to the extent it is found deficient, the empowered enforcement officer may attach any other asset, which is called the alternate attachable property, deemed tainted property of the person accused of offense of money laundering, provided it is near or equivalent in value to the former. So the order of confiscation being restricted to take over by the government of illicit gains of crime. If a person accused of the offense of money laundering objects to the attachment, his claim being the property attached was not acquired from criminal activity, the burden of proving facts lies to be discharged by him. The objective of PMLA being distinct from the purpose of SARFAC, insolvency, IBC, income tax, the latter three legislations do not prevail over the former. So in this matter, the Delhi High Court said that IBC, etc. do not prevail over the PMLA. PMLA, by virtue of Section 71, has overriding effect over other existing laws in the matter of dealing with the money laundering. PMLA, RDBA, SARFAESI, and insolvency must coexist, each to be construed and enforced in harmony, without one being in derogation of the other with regard to the assets respecting which there is material available to show the same have been derived or obtained as a result of criminal activity. So this judgment created a problem at that time, and it is still being used by the AA under PMLA, that is the ED, for their use. If you wish to go through this, I'm not going through the all the paras here. I'm just taking up those which affect the IBC. Now they say if the order confirming the attachment has attained finality, or if the order of confiscation has been passed, or if the trial of a case under Section 4 has commenced, the claim of a property asserting to have acted bona fide or having legitimate interest in the nature mentioned above will be inquired into and adjudicated upon only by the special court. What was the effect of insertion of Section 32A? The Parliament promulgated this section was inserted. A close reading of Section 32A 1 and 2 establishes that the legislature, in its wisdom, has erected two unfaltering barriers. It firstly prescribes that the offense which may entail either prosecution of the debtor or proceeding against his property must be one which was committed prior to the commencement of CR. Secondly, the cessation of liability for the offense committed is to occur the moment when a resolution is approved or upon sale of liquidation assets. The provision is unequivocal terms terminates the prospect of prosecution of an action against the properties on the happening of two events: date from which plan is approved or the sale of liquidation assets is made. So what does it mean? That during the moratorium process period, we call it moratorium, but they have not called it as such. They say that this protection shall arise only after approval of the plan. And during that period, the protection under 32A cannot be availed. Committee agreed that the property of a CD, when taken over by an RA or when sold to a bona fide bidder in liquidation, should be protected. But committee also agreed that protection given to the CD's assets should in no way prevent the relevant investigating authorities from taking action against the property or persons in the erstwhile management of the CD that may have been involved in commission of such criminal offense. So it is necessary to understand the position of government under the PMLA is not similar to a secured creditor, thereby equating the position and blatantly stating that IBC shall override after the insertion of Section 32A shall severely affect the legislative aim and policies of the PMLA. The Honorable High Court has also explained the issue and provided solutions to the same. It held that court notes that the relief as framed in the writ petition essentially seek a restraint against the respondent from interfering in the resolution process, which had been set in motion. The challenge cannot stand eclipsed merely on the ground of issuance of provisional order. The authority of respondent to move against the properties of CD after liquidation has reached a stage where a particular measure has been approved by AA is a question which will still arrive. The court also notes that the challenge to the action of respondent is raised on jurisdictional grounds. That issue cannot be recognized to stand interdicted merely on account of a provisional order of attachment. The preliminary objection is thus negative. After considering the rival submissions of primacy between IBC and PMLA, the court bears in mind that when dealing with the two statutes, which may independently employ a legislative command for their provisions to have effect, notwithstanding anything to the contrary contained in any other law, the first question that must be answered is whether there is, in fact, an element of irreconcilability and incompatibility in the operation of two statutes which cannot be harmonized. The issue of incompatibility in operation of the two statutes should not be answered on a mere perceived or facial plane, but on a deeper and meticulous examination. The IBC can be aptly described an economic measure marking a significant departure from the way that was treated for centuries. IBC is firstly envisaged to be an umbrella restrictively with so and so. PMLA, on the other hand, is a statute fundamentally concerned with trying offences relating to money laundering. Viewed in that backdrop, it is evident that two statutes essentially operate over distinct subjects and subserve separate legislative aims and policies. While the authorities under IBC are concerned with timely resolution of debt, while those under PMLA are concerned with criminality attached to the offense of money laundering. So the authorities must be accorded sufficient leeway to discharge their obligations under the two statutes. The aspect of legislative fields of IBC and PMLA and the imperative to strike a correct balance was rightly noticed and answered by the learned judge in Axis Bank case. The issue of reconciliation insofar as the present cause is concerned needs to be answered solely on the anvil of 32A. Once the legislature has chosen to step in and introduce a specific provision for cessation of liability, it is that alone which must govern, resolve, and determine the extent to which powers under PMLA can be exercised. It went on, and ultimately they decided that Section 32A in an unambiguous manner specify the approval of resolution plan in accordance with the procedure laid down in Chapter 2 as a seminal event for the bar created therein coming into effect. Drawing substance from there, this court comes to a conclusion that the approval of the measure to be implemented in the liquidation process by the AA must be held to constitute the trigger event for the statutory bar enshrined in 32A coming into effect. It must consequently be held that the power to attach as conferred by Section 5 would cease to be exercisable once any of the measures specified under 32 of regulations comes to be adopted and approved by the AA. Expression sale of assets must be construed accordingly. The power otherwise vested in respondent under PMLA to provisionally attach or move against the properties would stand foreclosed once the AA comes to approve the mode selected in the course of liquidation. To this extent, and upon the AA approving the particular mode, PMLA must yield. So, 32A was held to have an impact on the approval of sale of the CD under liquidation or on the approval of the resolution plan. In Messrs. Prakash Industries Limited versus Union of India and another, it was held that ED can only probe offences listed under PMLA. Delhi High Court has quashed provisional attachment orders issued 4 years ago against two firms and stated that the ED can only probe offences defined under PMLA and not assume predicate offences noticed during the course of the case. The law designates authorities to investigate the listed predicate offences, and the ED should share information with concerned agencies for appropriate action rather than arrogate power to probe into those offences. High Court's verdict came while allowing two separate petitions filed by Prakash Industry and Prakash Thermal, challenging the provisional orders issued by ED to seize their assets. ED began the probe after taking up a CBI case against Prakash Industry, accused of false declaration with Bombay Stock Exchange to boost value of their share. The entities were allocated Fatehpur Coal Block in Chhattisgarh. What needs to be emphasized is that PMLA empowers the ED to investigate Section 3 offences only. Its power to investigate and inquire is confined to the offence of money laundering as defined in that section. However, the same cannot be read as enabling it to assume from the material that it may gather in course of that investigation when a predicate offence stands committed. In Shiv Saran High Court judgment, we have seen that jurisdiction under 14 seized upon Section 32A So court emphasized that the approval order for resolution was not challenged by ED, required the release of attached properties. So 32A prevailed. It concluded that NCLT's interpretation and application of 32A did not undermine PMLA, but the stated that quasi-judicial authority, when exercising powers akin to civil courts, play a distinct role separate from the executive functions. They serve as a statutory check on the executive bound by the Supreme Court rulings. It is imperative that these bodies adhere to Supreme Court decisions to prevent unnecessary legal disputes. So the judgment was the attachment seized pursuant to section 32A and with the approval of the resolution plan. So what is the balanced approach? Now, have we reached to a conclusion whether both of them can continue together, or should one be stopped during section 14 period? Should one be stopped after 32A? It is hoped that the order that will be passed by Apex Court in pending matters would clarify, but at the High Court level, at the Honorable High Court level in Shiv Saran also we have seen, and in recent judgment, Delhi High Court judgment also we have seen that they have time and again given importance to the plan approval or the sale of assets in liquidation period, the importance of section 32A, and they still say that after the approval of the plan it is all right, but during the CIRP period and in case the plan does not get approved, or the CD goes into liquidation, the assets are not sold, not liquidation, the dissolution, if the assets are not sold actually, then would the PMLA come into effect again? Will they resume? And what are the answers to the question whether assets attached either prior to or during the CRP would be considered in the pool of CD's assets by the SRA? Whether ED could be considered as a creditor under action under PMLA being criminal, whether the same could be allowed to continue against assets standing in the name of CD. Given the objectives of both the statutes, the Apex Court may strike a balance of ensuring successful revival of stressed entities without allowing offenders to go scot-free with laundered money. So what do we derive out of this discussion? No blanket rule. In all the cases, the factors related to that case have to be considered. Approval of CRP, the origin of scheduled offense, generation of proceeds of crime, committing offense of money laundering, interlinkage between the assets confiscated and proceeds of crime, involvement of new management in any of the offense, etc. Objectives are significant. So IBC encourages the revival of stress assets, stress companies, and PMLA strives against the money laundering offenses to prohibit criminals to enjoy the proceeds of crime. Hence, the utmost priority is to strike a balanced approach along with catching hold of offenders of money laundering to remove the ambiguity of overriding effect. Everyone is eyeing the Supreme Court order on the subject. To balance out the objectives of both the acts, the investigating authority like ED, SEBI, etc. might be considered as operational creditors. This is one view. Thus, as a rule of interpretation, courts should apply harmonious construction between those two conflicting laws and should ensure that objectives of both the statutes are met. At the same time, the government should take steps to deal with ambiguities and clear the position concerning those ambiguities. The power of PMLA to attach the assets is affected as and when the plan is approved and after the impact of 32A. While the IBC can play its part in timely resolution and realization, ecosystem will have to look beyond IBC framework in silos and strive to connect the dots toward the next. It is concerted effort by multiple policy initiatives, well sharpened by regulatory forbearance and fortitude, and action at the ecosystem level that ensures the economy taking meaningful strides. So what are we concluding out of this? As we have seen, that objective of PMLA is to stop the criminal to enjoy the proceeds of crime. And if the property relates to CD, which is under CIRP, then sufficient steps should be taken so that in case a clear trail can be made for the money which has been which has originated from the proceeds of crime, in case that trail can be established, then the asset should be taken over by the central government. I have that personal view. But in case that clear trail is not established, then the asset should belong to CD and it should be given to the SRA. But this gives a sufficient leeway to the offenders for taking advantage of the immunity given under moratorium and 32A. So that is my take on it. In case anyone has any questions, in case you wish to discuss anything further, we can talk regarding this or on the IBC or on the other subjects if you have anything to share. Since I was speaking alone, so I have already covered what I had for 3 hours. If you have anything to share, if you have found any of the PMLA matters disturbing your CRP, you can share your experiences. In one matter, I have seen PMLA orders, not orders, the show cause notice given to the CD during CRP period, and the reply has been made, has been sent to them, which they have not accepted. And they have given that on the expiry of the period granted in the show cause notice, we will come and attach your property. And this is not a sufficient ground that IBC, that CRP is running. So now we are going for an appeal against that. We are running that process through the appellate, and thereafter we'll go to NCLT in case they do not take up our cause. If you have anything to share on the subject, we can share that now. We can discuss. Nobody? No one has encountered such a situation where PMLA was initiated during the CRP or it was already there in the process? Has anyone shared such a situation? So shall we close the session? Anjali, can we close the session then? There is no question. आशु जी, आप कुछ कहना चाहते हैं? Is there somebody who wants to say something? Shall we close the session, Anjali? No, no question. Anybody is having any views on which act shall prevail, which should prevail? It's a right of central government under various laws. As per UN directive, they have a right to confiscate their property, and the proceeds of crime should get back to them. Property should vest in them. They should realize that money. Or don't you think the promoters are taking advantage of this situation? Nothing. And no one is having any experience on the subject, right? those who are writing on the chat box can also unmute themselves and something, because it is very difficult for a single person to keep speaking. Okay, so then let's close the session. Anjali,
Yes, ma'am.
shall we close the session because there are no further questions?
Sure, ma'am. Sure, we can close it. Thank you very much, ma'am, for giving your valuable time and sharing your thoughts and experience on the topic. And thank you very much, participants, for hearing the. Ma'am, please share the presentation also.
Sure, thank you. Thank you, Ji, thank you.